judicial process. Whatever is available should be put to the accused person. And then to his lawyer. Then he can say, yes, I'm pleading guilty, or I'm not pleading guilty. Court participation. I've said here, this is the key, much as the lawmaker used the may instead of must. Do we have that 2016 instrument? Can someone read it for me? Let me get mine. 8, something like 8.3.
The court may participate in pre-bargain discussions.
The court may participate. So what if I don't want to? I'm independent. No one directs me on what to do. The law is very clear. The court may participate. That was the position until the matter went to Court of Appeal, and the Court of Appeal, I don't remember the case, Court of Appeal decided that you have no option but to participate in the process. But the law is still the way we expressed it. It is may. The court may. But my lords, your worships, we are inviting you to participate, to read it as if it is a must. Because Court of Appeal at least has said so, and why not? The court may participate, and so on. The usual result is for the defense and the prosecution to keep the court in the know of what's going on as regards the negotiations. That's what happens. To that extent, the negotiation process is driven by court. The process is driven by court to avoid unnecessary delays. It's like mediation. Even in mediation, the process is driven by court. You refer the matter to a mediator. This mediator should return the file within 2 months. And who allows an extension in mediation beyond the 60 days? The court, the trial court, or the mediator? You know, mediators are extending the time. But that's not proper. What we had in mind was that the matter would now go to the judge, and the lawyers, the parties would say, we are still talking. And the judge would say, okay, continue talking. But now, we've given opportunity to mediators, even those who are not judges, who are not lawyers, to participate. No, to extend the time. However, as regards the appropriate sentence to impose, the law makes it mandatory for the parties to consult the court on the sentence being recommended before the matter proceeds to court for the court to approve and record the outcome. What am I saying? People should come to you in your chambers to say this accused person is admitting and he is accepting 20 years imprisonment. Killing. Huh? So you die. But some deaths are more horrible than others. At that stage, you are at liberty to say, I won't allow this sentence. Please go and then you can even suggest to them what sentence you think would be appropriate in the circumstances. But you can't impose your own sentence. You are requesting them to go and renegotiate. We went through negotiation yesterday with Mr. Francis Atoke. That same negotiation extends to plea bargaining. Come back. You have to negotiate a year. So to this extent, court's participation is not optional. You have to participate in the proceedings. Plea bargain agreement must be executed as prescribed in the form set out in Schedule 1 and filed in court. Don't allow them to bring their own document, their own agreement. There is a Schedule 1. We don't have time to go to that one. But please, make sure you don't come up with your own agreement when it comes to plea bargaining. It must be explained to the accused person in the language he or she understands best. That means, my lords, your worships, you have to find out whether this person understood the nature and extent of the sentence they are talking about. Don't assume. I know some people say the lawyer is there to do the job, to advise. No, this lawyer may not have done it. Before it is signed, the prosecution should ensure that the interests of the victim, the interests of the complainant, and the interests of the community You've heard of impact assessment statements. Have you? Yes. Consult that one. If need be, bring some. Of course, in some cases, the victim is not there. At least there is a complainant, the relative, who should participate. These interests are reflected in factors like the nature of the offense and the manner of its commission, the criminal record of the accused, if any, the loss or damage suffered by the victim or the complainant, the interests of the community. How do you ensure interests of the community? How? Do you allow the chairman LC1 to come and give you some information? When we were in Uguru, we were told it is being done. LCs are going to court to say this man should be punished, and should be punished heavily. Yes. Interests of the community impact statement, or any other relevant information. Let's go to the recording of the agreement in court or by court. The court must inform the accused person of his or her trial rights. This is something we've been taking for granted. Who of us remembers some of those rights? The right to keep silent. Yes, the right to be found guilty or innocent. The right to keep quiet. Which other? The right to a full trial. Thank you. The right to call witnesses in the case. Those rights must be explained by court. Don't leave it to the lawyers holding brief. Please don't. Every judicial officer is presumed to know these trial rights. Surprisingly, some of them assume that because the accused is represented, therefore they don't have to waste time on them. Wrong. And that's where we get issues. Once the court is satisfied that a factual basis for the agreement exists, it will pass on the agreement to the accused for his or her final signature. In court, in open court. The rules provide for instances when the court can reject the plea bargain agreement where it feels it may occasion a miscarriage of justice to either party. Have we exercised that right by court? The parties have negotiated. They've agreed on what they consider to be an appropriate sentence. You've advised them. They've refused to
the court.
Yes, but before they come to you, the parties will sign. Yes, there is a place for you to sign. There is another place for you to sign in open court. And that's where I'm saying, that's where you'll have to explain the trial rights. You know, have you been given this situation? Have you been... Yes. We are now getting into the practical aspect of it.
My Lord, I'm sorry to interject.
No, this is why we are here.
The court or the judicial officer must participate.
Yes.
During a bargain, they will approach you and give you their bargain.
Yes.
Isn't that the time you advise and say, this sentence you are proposing is not good enough, go back and renegotiate?
Yes.
So, at the time we are going to the court, are we in agreement? Do we go to the court when the judge or the judicial officer is not aware of what has transpired? Because I believe his participation is aimed at solving those issues. So I needed that clarification. The participation of the judicial officer before, and then you are at the court, in the court, and you can't agree.
You can't agree.
How do you reconcile the two?
Okay. Let's give it to my Lord Alan.
I think Justice Kwizeroke brings out a point that we all suffer from. When you go to handle a session, you have 40 matters, 50 matters, everything is happening very fast. There is a tendency for the state attorneys and the lawyers to bring a matter to you in court. And because usually you are tired, you're concluding, you end up being forced to consider your input in court, which is not the normal procedure. Procedurally, it should be, if they are proposing a plea bargaining in a matter, you would raise it with them. Do you have any matters where there is a plea bargain? If it's not an official plea bargaining session. If it's an official plea bargaining session, there is a pre-meeting where you have a meeting before you start the session. And in that session, the state attorneys or the defense lawyers will tell you, we have agreed on these sentences if it's a plea bargaining camp. But if it's a normal trial, normal criminal session, and somebody expresses interest, it would be proper to ask, do you have any case where people are intending to plea bargain? And when they do so, it would be prudent to adjourn, go to chambers, where they then can brief you, and then the opposite side briefs you. You consider if there's a community impact statement, you consider the facts of the case, you consider the sentence they are proposing. If it is a case where they are saying want to give 3 years, in a case of aggravated defilement, where they defiled a child of 1 year, the child lost a uterus, the child had to get sick, was infected, you also say, no, these years are impossible. So in that way, you'll be rejecting and advising them in chambers, not in open court. So this discussion shouldn't be happening in open court where you have the accused there and there, because you're not having the engagement. At the end of the day, it is a decision of the judicial officer, and that decision of the judicial officer, you should own it after you've had that engagement. It should be in chambers, yeah.
Anyone with a contrary view?
But if I could
supplementary?
add a supplementary. I understand His Lordship Kwizera's concern is, why would the court be withdrawing during the proceedings when it has had the opportunity to for the consultation at the start? In reality, that consultation and your decision is dependent on what the state tells you and what the defense has agreed as the facts. And oftentimes, they may come to you, sometimes they come when they have not even consulted the victim, they may tell you the victim is not available, or you may have facts that are not quite complete. And then on that basis of what they have presented to you, you have probed, then on that basis you agree to maybe 20 years for the murder. All right? And then when you go to court, finally to confirm it, maybe the victim has come, maybe some certain facts come out as they are being presented that show a more gory, what Justice Bamwine talked about, that some murders are really, really bad. And probably you hadn't even addressed your mind to what the post-mortem says. Maybe this person was killed and, beaten so brutally. Then you change your mind. And I think at that point it is right, it is okay. So if your consultation does not give you all the appropriate facts, sometimes it comes out during the proceedings. And at that point, you still can withdraw. As a court, you can say, considering these facts that are now before me, that paint a more serious picture, I will not take the sentence that we had agreed. There are exceptions, yes, but they do exist.
So remember, my lords, your worships, even at this stage, either party can opt out. Either party can opt out. Yes. I feel I'm not, okay. I've changed my mind.
Just another view.
Yes.
I think what is critical is for the judicial officer to realize that you control your court at any level before you sentence. So you have a duty to ensure that justice is done in every case.
Yes.
So whatever they bring before you, you can reject and advise them to renegotiate. What you should not do is to impose your own sentence.
Yes, this one now.
That is wrong. But you can advise them, please go back. And that you have the capacity to do it at any stage.
Yes.
What you don't have the capacity to do is they bring a sentence and you impose your own. Because that is not an agreement.
Yes. Thank you. Thank
My
you.
Lord, yes, I was actually going to give an example on that.
Oh, more severe or less severe?
Yeah.
I think more or less are the same.
Yes.
You do not
The
impose
law-
your own sentence, whether it's more or less.
The law
you-
makes it very clear that court should not impose a sentence more severe than that is the one contained in the agreement. Yeah. Uh-huh.
Yeah, but you see, a pre-bargain agreement, the essence is that there is a pre-bargain and
Yes.
there is an agreement.
Yes.
Should you alter that sentence by either an enhancement or
Or
reduction?
reduction.
I think the proper thing is to accept the agreement as it is, do not alter it.
Yeah.
My Lord, I wanted to give another example.
Yes.
I had a case where people came for a plea bargain and they discussed, I think it was after we agreed on the years and the person was there and we proceeded. But the victim, when we were talking to the accused person, he raised his hand earlier on and said, you know, I'm actually a child. Now we're in court.
Yeah.
I was a child at that time. He was a big person now. Now he raised and said, but I was a child at that time. So then it became an issue, and later on, I think the mother came with a birth certificate and all that. So that is also the other flip side, that a person can agree to 15 years, and they are discussing, and when they go to their lawyers internally, they are in prison, the lawyers tell them, but if you're a child then, this is what the law says, and they raise it. So if you go ahead and say I'm confirming 15, this is where you may say, okay, I'm holding it here. I think you might have to go back and reconsider some aspects. And once the facts come out clearly, as in that case, we all know the sentence you can only give out in respect to a child. So that is a flip side of what can happen in a courtroom. I think the key thing is that the moment you agree in the chambers on the years, you look at the facts and you're in agreement and you're ready, go to court. Your own remedy at that stage in court is to hold the process and take back for renegotiation. Not to say, I've realized now you're a child, I think I'm going to give you maximum of 3 years. It's say, let's go back, we discuss, then it goes back into forming a formal agreement. Because then the victims also must be informed that whereas this person has agreed, but this is also what the law says, and I'm tied up in this aspect.
Yeah. Thank you so much. In fact, some people are now appealing against those sentences. Yes. The child will not bring up that issue of age. And the judge or magistrate will not have considered the same. After all, the parties have agreed. And the child on appeal is saying, I was below 18 at the time of the commission of the offense. And that fact was not considered. Court of appeal will interfere with the sentence. Yes. I hear you don't interfere, you correct. Period spent on remand. We now know that the period spent on remand is neither a mitigating nor an aggravating factor. It's a constitutional requirement that it be taken into account during the sentencing process. The sentencing guidelines as well as case law make it clear that it be deducted from the recommended sentence. So the record ought to show that the judge deducted it arithmetically. There is no debate, no more debate on this now. So if the parties have agreed that the sentence is 20 years imprisonment, let them not tell you that they considered also the period spent on remand. No, that's not their business. That one is for you, my lords, your worships. So you deduct the 7 years spent on remand, and the sentence will now be 20 minus 7, which is 13. That is the sentence to be served. I hope now we are no longer mixed. You remember the matter went to Supreme Court. Supreme Court said, no, you don't have to be that mathematics wizard. No. You don't have to. But now the Supreme Court has changed its position. The law is very clear. You have to deduct it yourself. Yes.
In cases, there's some cases, maybe there was a time when we went around under jails, touring the prisons, and we found in some cases people have been on remand for 13 years. Now, in such a case, if the offense was supposed to add a maximum sentence of 7, and you have served 13 years, what happens?
Yes.
You discharge the accused. No, you consider, the point is that you consider the circumstances of that case.
Yes.
And say, I would have sentenced you to 7 years. You have already spent more than 7 years. I hereby discharge you. And then the matter would end there. You don't sentence him to what you consider to be more than the period he should have served.
Yes. The land SG is...
I think Mr. Toke's argument is, shall we have a judge who's bold enough to say you served more, so you have credit in case you commit another offense in the future?
What he's saying...
I was actually talking about, because in the US, I did criminal justice.
Let's listen to each other.
I did criminal justice in Aberdeen, University of Aberdeen. And they considered also these things way before we had even started thinking about a plea bargain.
Yes.
And then I had a stint in the US, whereby from 1989 to today, there have been cases of that nature. Over 3,400 of them where people have been in remand, and then later they realize that they have been in remand for long. Now, what happens is that if in the US it is coupled with, if it is wrongful accusation, wrongful charges, then they even pay for that time. So you find a person has been in jail maybe for 20 years, and maybe that is different because he's exonerated. But this is a case where somebody has not been taken to court because maybe he refused to, I don't know, whatever complaints you are talking about my lord, that people say, if you don't take a plea bargain, you'll rot in jail. That is what is happening outside there now. So if somebody is in remand, recently there were 2 brothers who were in jail on remand for 7 years. And, well, the judge has the authority to discharge that person. But what about this period that this person has spent? If he were to go to serve his sentence, he would have served 3 years. But now he has been given a bonus of 4 years. What happens in that case? Isn't it, when you talk about justice, isn't it unjust for somebody to be punished for a crime they did not, to be sentenced for beyond the mandatory period?
There is a way the DPP's office handles that.
All right. So what happens is, in practice,
yes,
it is not common. Why do I say that? Because we know the maximum sentence for certain offenses.
Yes.
And when the state attorney and the defense or the accused are negotiating, the truth is they have in mind that this person has been here for 7 years. And it is not common, for example, in the High Court, for them to say, for this case, we are going to give you 3 when you've been on remand for 7. It usually happens in cases of juveniles. A juvenile offender who has been somehow lost in the system and for over 3 years has been on remand. And yet there is the maximum penalty that can be given.
Yeah, 3 years.
So then exactly what Justice Butera said happens. You give him the 3 years, he has already served. I mean, he goes home, he's discharged with immediate effect. I think the question of, I have been on remand for a longer period,
Yeah.
is something that probably will need to be tested in our legal system. In other jurisdictions, they bring suits against the state seeking for all manner of reparations for that kind of infringement. We haven't had that yet. And I don't know how a judge who is faced with the maximum of 3 years for this juvenile, you cannot pass an illegal sentence. The most you can do is give him 3 years and discharge. Of course, that leaves that aspect of his being on detention for another maybe extra 6 months or 1 year unattended to, but I don't know if that is the problem of the judge. I think that we may probably, as our jurisdiction and our jurisprudence grows, we might see some suits coming up. I haven't experienced one yet, but I see that's also what happens in the Americas and other jurisdictions.
That was the issue that
I will come. Hey.
That's what I've not understood in our type of work we do in this country. When the Constitution said a speedy, a quick and speedy hearing, what period is it thinking about? Does it exist?
No.
Yeah, because you see, we now have people of 5 years on remand. We have people of 7 years. We have, and by the look of things, their cases will not even be heard this year. So do we still fall in the right seat of the quick and speedy hearing, of the one the Constitution is referring to?
No, when you apply plea bargaining.
Because otherwise we are breaching the Constitution every
when
day.
When you apply plea bargaining strictly, you will get there. We are trying to get there, my lord. And you, my lord,
was
here.
addressed.
Yes. Ah, okay. That's why I'm saying plea bargaining is one of the silver bullets for reducing prison congestion. If well handled, please handle it well. Follow the rules. Where there is a need to amend the rules, recommend. But the moment you follow this one, what is happening, the case, the scenario Justice Wangtus is raising is what we started off with. We are forcing people to plead guilty in this country. Because if I don't know whether I will ever be tried, I see some of my colleagues going out to rejoin their families. Why should I? It's unacceptable. So that's for the principal judge and the powers that be.
Yes, it could be a silver bullet, but I'm seeing a situation when you reject the agreement in the court, you are not supposed to handle that case. So I have a chief magistrate who is handling Buweju and Bushenyi. This is a case of defilement, simple defilement. He has rejected this agreement. He's the only chief magistrate there. So he packs this person until another magistrate comes. And it is very rare that we are going to get maybe a visiting chief magistrate to handle this matter. So we shall wait for His Worship Saidi to first be transferred, then another Chief Magistrate handles. So how is it going to be a silver bullet there?
But we had a similar situation in Fort Portal. You remember that argument? In Fort Portal, there is a chief magistrate who said you can hear the matter. After all, the law does not prohibit it. But you've participated in the proceedings. Why don't you involve the principal judge to get you another chief magistrate to go and hear the matter? Do we have a shortage of chief magistrates?
Yes. We are under pressure to have returns. We are under pressure to have returns. But we also facts, they are relying on your charge sheet. But you know that this person has been on remand for probably a year or so, and you want to conclude. So you find that you're between a rock and a hard place, and you have to allow whatever they state now. Someone says, I'm willing to plead guilty, but I'll only take 1 year, and that is exactly the time that they have spent on remand, and you're also stuck with a file, so you just say, okay, let's take it that way. But you know deep within that, this is maybe defilement. I think we should have known the facts a bit more. We should have had more details, but then you're stuck with that kind of situation. And then also, I'm happy that the acting PJ is here. The issue time, you'll be able to help us reconcile that form and this. I don't have it right now, but I know that it was there, and we were advised to rely on it if plea bargain is to succeed. But also, my lord, with the challenges that we have, we normally explain these rights, and then we go through the agreement, and then we get to court. And because the state is the one preparing these plea bargain agreements, they even tell you, we don't have stationery, we can do this later. And then I have seen appeals where someone says there was no agreement because we don't have the actual plea bargain form. But on the record, you know that we went through the entire process with this accused person, and they actually admitted.
That's why I'm saying you have to use the other format. It is there. You can't run away from that.
Okay.
Yes.
And then also, my lord, maybe a proposal for reconsideration. Is there such a thing? I think what we have been doing is quasi-plea bargain, because you go through all these processes, but somehow you know that you're not doing the actual plea bargain as in black and white, but then somehow you have convinced this accused person to accept, and then they have accepted and you have recorded. Is that where we should now divert and go like just a normal plea of guilt, or still maintain that it's a plea bargain and then?
In the lower court, in the magistrate's court, I get your challenge because you don't have lawyers and state brief. In high court, that one is not there. Every accused person is represented. So in the lower court, you are there to make sure justice is done.
So you're okay in our
until such time. I don't know whether we are working on it. You are okay maybe to invent some things in the interest of justice, because we don't have those people, those lawyers who would assist us. Yes.
I think you began from the statement that the plea bargain is an agreement between the prosecution, the accused person, and later involvement of the victim.
Yes.
Now, if you don't have a prosecutor who is conducting the negotiation and give an appropriate sentence, but don't try to enter into a plea bargain agreement where you don't have a state attorney.
Where there is no state attorney.
What you can do is conduct a plea of guilt and sentence. But on things like paper, I think let's be practical. We now know that this form, you need this form. Why don't you print and keep copies? Rather than try to find difficulties about you can't move away from the form. Just don't try to move away from the form. Simply don't try to work without following these rules. It is wrong, it's not correct.
I think as the DCJ Emeritus stated, we can't walk away from the agreement, otherwise it won't be plea bargaining. So we need to have those copies of those agreements at our stations and move with it. But also the other flip side which I wanted to share, and I used to see it mostly in Kampala, some of these accused people are very tactful. They have had enough training inside there. Some of them are actually good experts in plea bargaining. So they will comfortably come. He will go along with the whole process. He will reach the last minute, raise his hand, and say, I have rejected it. They know exactly where to stop. And it is meant to tactfully eliminate you as a judicial officer handling the matter. That is the first thing. Some things you have no choice about it. Now at that stage, it would be prudent if you're the chief magistrate or magistrate, you write to your immediate supervisor, such that if need has to be done, the file can be moved to another person. Any aggravating or mitigating anything you missed from the facts. And in that way, you don't have a scenario where you came up, you participated. Because if they tell the person we can't take back below, for example, you filed a 2-year-old, and I said I cannot go below 12 years. Automatically, that one you don't even bring him to say you're going to try with a discussion. There are cases that are quite clear. If it's a murder, and sort of manslaughter, we know. So in that way, it becomes a way in which you are guiding the people before they go to negotiate without you participating, such that if they don't agree that side, then you hear the matter and you're not eliminated. So these are some, I think, of the tactics that you learn from experience and you gain to learn how to go forward. But I think we need to stick to those rules and formulate your own ways of handling it within the law. I think that is the most important.
Within the rules. Finally, my Lord PJ. Yeah, this is the final. Okay. There was a complaint which we gathered, I think, which we got in Gulu, that the DPP has made it difficult for the parties to negotiate. There is, I think the DPP issued some instructions that some cases should not be below some threshold. And some judicial officers were saying, no, I'm the one in charge of the negotiation. So if I've directed, if I've given green light, then we are not bound by that that order of the DPP to the state attorneys. Do we have someone who can? I've never seen that.
Okay, I could speak to it, though I know we have colleagues from DPP's office here. I think what the Director of Public Prosecution did was to issue plea bargain guidelines for its staff, being representatives of victims of crime, to kind of guide the prosecutors on what is acceptable and what is not, a kind of check system. Because whether we like it or not, plea bargain is also subject and susceptible to abuse. So that was a guideline for her prosecutors, almost like what His Lordship Alan was talking about when he said, for cases where a victim of defilement is below 3, I will not look at a sentence that falls below this number of years. And so that was a guideline, and that really is what it is. It guides the prosecutors. But that does not stop the prosecutors, if they have disagreed with the defense lawyers during the consultation. What is the consultation for? To seek the advice of the judicial officer on what would be an appropriate sentence. So I don't think that the defense need to be intimidated in any way. During the consultation process, if a prosecutor has stuck to his guns for a higher sentence and they think it deserves a lower sentence, consult the trial judge. And the trial judge will sort out that impasse if possible.
There are situations where accused persons have walked away from court with a handshake over sentence. After murdering someone, you are walking away with a handshake, 4 years imprisonment. And the state has sealed, the judge has signed, the state attorney has accepted. But when it comes to the community participation now, it's unacceptable. Should the DPP allow that situation to continue? Huh? Yes.
May I give an example of that?
Yes.
I want to get tired of quoting a case, a factual case that happened in this jurisdiction. It was in Ibanda Town Council. A lady had divorced with her husband. She went to run a bar in Ibanda Town and was doing her businesses. The former husband knew where she was staying. He walked from his village, came to Ibanda Town, bought a panga, took it to a welder, sharpened it, came in broad daylight, and cut her into pieces. There was a criminal session in Ibanda. This I won't call him a gentleman, this suspect Mbarara appears before a judge and took a plea for manslaughter and was sentenced to 4 years imprisonment. And the conviction was for manslaughter. I think such incidents have to really be avoided because certainly the state attorney was wrong, but I think the judge was not right either.
Okay.
Allow me to sit down and thank you for being keen participants.
My Lord PJ Emeritus, thank you very, very much for that overview. I get the feeling that there are still a number of questions. I did not expect the kind of interest or practical sharings during your plenary of what the challenges are on the ground. And we are interested in that. However, we are working within grab your teas, and we will proceed to have simulations in the groups that will be shared with us. I think there will be 3 groups, and I'll hand over to JTI to define this better. And could I have your attention for a minute, please? So we will reconvene at precisely 11 in the groups and do the simulations. But hopefully we will have time later to go into whatever questions that you may have that have not been covered during this plenary. So I would like to hand over to you, ADR, Registrar ADR. Would you like to guide us on how the simulations will be conducted?
Yes, please, my Lord, Honorable, the Principal Judge. I thank you so much for the opportunity, my Lord. My Lords and your worships, we had 4 groups yesterday. We are going to have 3 groups, and each group is going to be given a set of facts in a criminal file. You'll study the file and be able to respond based on this question paper that has been given to you, my Lords. We are going to request that the team for Justice Kafuzi and for Justice Carol emerge into one group. Then Justice Kwizera will maintain his group and Justice Alan will maintain his group. One group will be sitting here, and then the other 2 groups will be sitting in the opposite room, my Lords. So when you come back from the break tea, we shall be going for the simulations, my Lord, and your worships. Thank you. Yes, that's what you're saying.
Can I get X-ray?
Yes, I think they are there. My lords and your worships, the team for Justice Kafus and Justice Kalori will come back here, and the other two teams, since they are smaller, they will go the other side. You are going to find the tables when we have put the facts, the files already on the tables, my lords. Thank you.
Yes, my lord. We have 3 court records. 1, 2, 3. So we are giving each group all the 3 records, and they are following these instructions.
My lords and your worships, can we please take our seats? The Honorable Principal Judge is calling the House to order. I request the members of the faculty team from ODPP's office to join the high table. Ms. Susan Wakabara, Council, Madam Lydia Nandaula, and Ms. Nachigude Margaret from ODPP, please take the high table with the Honorable Principal Judge. I invite you, my Lord, the Honorable, the Principal Judge, to please take us through this next session. Thank you.
Thank you, Your Worship. Welcome back from the discussions to Group 1 and Group 2's presentation. Susan Wakabala has been brought on board, and there was a defense, criminal defense bar that had challenges. And so she helps us to do training for defense lawyers, practically on the ground during the camps. She has an impressive CV, 18 years of criminal defense work, head of subject, criminal proceedings at the Law Development Center from 2022 to 2024. She now heads trial advocacy at the center. She was part of the pilot of plea bargain before the rules were made. And she has been practicing both at all levels, including the Court of Appeal. So she has a great experience. And the Supreme Court. I'm sorry, I forgot. And the Supreme Court. So welcome, Susan. Next, Nachigude Margaret. She's an Assistant Director of Public Prosecutions, working with the Office of the DPP. She has been the focal point for plea bargain since 2018, and again working closely with the Judiciary on part. She heads the Department of General Crimes casework. She also heads daily hearings, which is a pilot we are running, and have criminal cases heard on a daily. So she heads the daily hearing. Let's join hands and welcome her. On my left, General Crimes, the department in the DPP, but also a foot soldier in daily hearings. She has been an integral part of the training and also the use of plea bargain in the criminal justice system. She has a lot of experience on that, very active in the camps and also at the criminal division.
So for my group, under the leadership of His Lordship Kafunzi and also Justice Caroli, this is what we discussed. So for the first is what we discussed. So for the first question, we were supposed to discuss and identify the gaps. So under question, these are some of the anomalies and gaps. It did not include one of the ingredients of the offense of murder. There was no mention on malice aforethought. So that's a major gap we saw. Secondly, on the agreement, the plea bargain agreement, under the accused person's name, they wrote the name of the lawyer, that was Lenny Peace, instead of bureaucrat as to whether the accused person actually understood the agreement. For the fourth one, the judge or the judicial officer did not sign on the agreement. And also there was no agreement as to the time or the sentence. Also, looking at the judge referred the matter to the judge referred the matter to the DR for reallocation. And yet the main concern or element that they did not agree on was with the sentencing. So what the judge should have done was to send them back to renegotiate on the sentencing rather than sending it to DR for reallocation because all the other terms had been agreed on. Also, the indictment does not specify the age of the accused person. So we do not know whether the accused was actually a juvenile offender or an adult. There's also no signature from Birungi Joy on the agreement. So it raises, this has been discussed. Brief facts, if you look at the agreement, it only says brief facts as per the charge sheet. There's need for, yes? Yes, by indictment. So there's need for the brief facts to be stated clearly on the charge sheet, on the agreement. Also looking at the part on sentencing information, they did not specify the aggravating factors. They only stated that the accused person died. So that is not aggravating enough. It was a bit scanty. And also, there is no impact statement or reference. It may not be mandatory to have an impact statement, but basing on 126 that requires that use of the community is considered, left out. And looking at the agreement, the accused person was not given a maximum opportunity to build on her mitigating factors. She only mentioned, there was only mention of the fact that which was not enough. This has been discussed, the issue on the sentencing. No interpreter. The agreement has a provision for the interpreter to sign, but the interpreter did not sign. So it still raises doubts as to whether he understood or not, or whether she was coerced. And then lastly, this has already been discussed, the major element, the fact that the judicial officer did not sign. So there is no agreement with. And then for part B of our question, it says, make proposals on the ideal plea bargain procedures and processes. So our first proposal was there's need for an interpreter in the process to ensure that the accused person actually understands, given that it's an agreement or contract. Secondly, there's need for involvement of all parties, including the victim or complainant, given that there's no impact assessment statement. Thirdly, there's need for full disclosure, which I think I forgot to mention under the agreement.
Your Worship, just a second. You're done with the first scenario.
We were only able to conclude the first scenario. We did not have time to.
I think the instructions were that you were doing one scenario, and then the next group did the second scenario. It had 4 parts, so she's still on the first.
I'm on the second part.
Part 2. All right. Please proceed.
So there was no full disclosure, which I ought to have mentioned under one of the gaps, but we mentioned it here under the proposals. So there is no evidence, there is no brief facts, there is no aggravating factors. The maximum sentence or the range within which court would sentence the accused person is not mentioned. Also, the opportunity for the accused person to mitigate wasn't provided for. So there is need for full disclosure. Number 4, there is need to take plea versus Republic, which was skipped when you look at the record. And then number 5, looking at the record, it does not have a session number. So how will the file be tracked? There is need to include that. Number 6, translation. There is need to translate plea bargain agreements into various languages. Although the language of court is English, most accused persons, or there are people who do not speak English, especially including the accused person in this matter, who speaks Luganda. And also, all the elements laid down under Rule 12.1 of the plea bargain rule should be considered. And there was an issue that we failed to find or get consensus on, and we needed guidance from the faculty. That's on Rule 5 of the plea bargain rules. That is all from... could she please raise it? My Lord, I'll give her an opportunity to raise it. Thank you very much.
Thank you. Part 2 tasked us to propose the way forward on plea bargain procedures and processes. We had a concern on Rule 5, which states that plea bargain can be initiated before a sentence is passed. We're looking at a scenario where a judicial officer has had maybe 10 witnesses, defense has closed, a conviction has been entered, a locutus done, and then the convict raises his hand that he intends to plea bargain. Our concern was, as a judicial officer, do you put the procedure, the trial procedure that has happened aside, and you venture into plea bargain? If it fails, what happens? However, I'm also alive to the High Court decision that gives a judicial officer discretion to proceed with sentencing at that stage, if the judicial officer is alive to the fact that the convict might be playing delaying tactics. But what happens if you give this accused person an opportunity to enter into that plea bargain, and you've put the procedure, the trial procedure that has happened aside, and again plea bargain fails? My proposal was that the rules have to be clear at that point. If a convict initiates plea bargain at that stage, so the concern is at that point, before sentencing, but you've had a trial, and then a convict wants to plea bargain.
Thank you very much, Group 1. I'm going to hand over to the faculty. You had the presentations from Group 1. Would you like to make some comments and also address that rather controversial issue that has just been raised by Your Worship? I think, my Lord Justice Wangutusi, it seems to be what you were also talking about. You got it from there. All right. So would you like to make a comment on their observations and presentations?
Thank you so much, my Lord the PJ. And I would like to thank the first group, the work done. I'll just give a few comments such that I can let my colleagues also add, subtract. So when you look at the scenario, we're basically looking at where an accused person is presented before court and then the plea bargain is introduced. And upon introducing of the plea bargain, then the accused person informs court that is not comfortable with the sentence. So there are certain things that I would think that would have stopped at a certain point, yeah? So the issue of, when you look at interpreter did not sign the plea bargain agreement, is it necessary at this point that the interpreter signs before the whole, before the going through the whole procedure of plea bargaining? The other is, okay, generally when you look at what we've done, first of all, the plea bargain agreement, one of the things we are looking at is that a plea bargain agreement has to be signed, has to be fully filled for purposes of the court, right? And by doing that, all parties who are part of the bargain have to append their signatures. We have case law to the effect that where, for example, the court does not sign a plea bargain agreement, the Court of Appeal has held that such an agreement is void. And that is the case of, what is the case? Baguma Vicent, yeah, versus Uganda, where the judicial officer did not sign, and then the court held that such an agreement was void. The agreement was set aside, and then the court went ahead by virtue of the powers vested into it and resentenced the accused person. So for purposes of saving onto the objective of plea bargain, that we are saving on resources, we are saving on the time, it is very essential that the plea bargain is filled such that we avoid such things. When the plea bargain agreement is before the court, as a judicial officer, make sure that all the parts are filled. Everything that needs to be filled is filled. Make sure you look through it and you're comfortable. You've also signed. If there's translation, the interpreter has signed before you go into sentencing the accused person to avoid issues of appeals. Then also, the other thing that we were looking at on that file is the issue of the record. Is it proper if a plea bargain agreement has failed? Is it proper that the next judicial officer who gets that file or gets allocated that file finds that record? Yeah? So that's another thing that we should look at in this. Then the other thing is, on that thing of the rule, personally, as defense counsel, I'm giving my side as defense counsel, yeah? I would think if I'm to interpret that rule, it says that the accused person can initiate a plea bargain anytime before sentence is passed. So as a judicial officer, to avoid the issues of, an appeal etc., maybe you can give him the opportunity, but in your mind, you know what has happened. You know that you are at the tail end of the proceedings, such that even if the bargain fails, because you have concluded the thing, you can go ahead and still pass your sentence. That would be my opinion as defense counsel. But I know we normally differ from the state, so maybe my colleagues would have a different view, and that would be okay. Thank you.
Chair, she talked about a failed plea bargain. And the court record is indicating that there's a failed plea bargain, but she did not give us what ideally should be done with such a court record, because another judicial officer will come in contact with that court record and will be aware that there was a failed plea bargain, and now they are supposed to try this case. So she didn't give us her take on it. She just left it hanging. Do you mind giving us your take?
Thank you, my lord. I think where a plea bargain has failed, as a judicial officer, you'd ensure that that record is taken off before the file is reallocated to avoid bias, and also for the other judicial officer to see what had transpired in this initial process.
Thank you very much, Group 1. I think you tried your best. I think it was well discussed and detailed. I saw that I observed that you went into the details of a correct procedure for plea bargain, but you also did not go into the fact that the court has to deduct the period spent on remand. Yes, that's very important. Yeah, but it's going to come up in other case scenarios. There are also other cases apart from the case of Baguma Vincent versus Uganda. There are other cases like the case of Musinguzi Apollo versus Uganda, criminal case, Court of Appeal criminal case number 240 of 2017, whereby the judge went into the details of querying whether the plea bargain was, the accused entered the plea bargain voluntarily, but did not convict, on the record there was no conviction sentence. So in that case, the plea bargain agreement was found to be illegal and the case was sent back for retrial. In that case, at what time can someone, an accused, enter into a plea bargain? Rule 5 talks about any time before sentencing, even after a judgment has been passed, any time before sentencing. My personal view was, I found that a bit controversial as my personal opinion, but I think what the judicial officer should consider is that you still remain with the discretion as long as you can make a decision on that, as long as it does not, it's in the interest of justice. You have to consider the interest of justice at that point, whether you should consider the accused to join a plea bargain after you have convicted and passed judgment. Thank you very much.
Thank you, my lord. I just wanted to add that she pointed out, the presenter pointed out a lot of anomalies, but some of them were just as a mistake. For example, she said the indictment never disclosed the fact that there was malice. That was a mistake on the side of the person who drafted the committal papers. And then the names of the lawyer and the accused person, interchanging them, that was an oversight in the process of preparing the scenario. But basically this was a scenario about a failed plea bargain. What happens when a plea bargain fails before one judicial officer, and after it is transferred to another judicial officer? What happens? And that is what my colleagues Susan and Madam Maggie were talking about, that in case it fails, to avoid bias and all that, I am also of the opinion that in case it fails and there is already a record shows that the accused person had agreed for 10 years, for example, 10 years for an offense of manslaughter, me, I would believe, I wouldn't differ so much from them, that bit of the years is not reflected on the record because it is going to create bias. If the person now changes their mind and they are going to plead not guilty before another judicial officer? Basically, the scenario was about a failed plea bargain and the fact that the agreement was not well filled. And remember, this is the only record we have. We have, apart from the proceeding, this is the only document we have on record and that supports the plea bargain. So the agreements have to be filled well. Thank you so much.
All right. We have quite a number of controversial issues arising. And especially that which was raised, I'm sorry I didn't get your name, but about Rule 5, that what happens if the accused person after conviction then says they're interested in plea bargain. There was a decision of Inensiko Adams versus Uganda. It was handled by Justice Mutonyi on appeal, and it dealt with a ground of appeal emanating from the trial magistrate's failure to follow the procedure. When the accused said he wanted to enter into a plea bargain, the magistrate thought it was a waste of time. Actually, the proceedings were as follows. The accused, after the trial had started and after having disturbed, I think, the courts and the defense and the accused and the prosecution over plea bargain several times, and it had failed. When the matter came up before court, the accused now says, I'm for plea bargaining. The state replies, the case came for trial, the accused was put on a list for plea bargain, but that plea bargain failed. The accused said, I'm willing to compensate the complainants. I admit I committed the offense. This is in the middle of the trial. And he says, I will pay 2 million shillings on 20th March 2017. The state, being angry, then says, let him pay the 2 million shillings from prison. In other words, I'm not interested in the plea bargain. So the trial magistrate went ahead, read the charges afresh, and instead of doing a plea bargain, entered a plea of guilty. So the matter went on appeal on quite a number of issues. And one of these that the trial judge addressed was, since he said he wanted to enter a plea bargain, the court ought to have accorded him that opportunity. And emphasized that as long as the sentence has not been entered, that's an option available. That was a High Court decision, and I know it has been cited with approval by the Court of Appeal in some areas. But the trial court, if you send this person back for plea bargain, what is the worst that can happen? One, remember plea bargain is an agreement. It is not by force. Oftentimes, the state attorneys, having got a conviction, will most likely say, what is the plea bargain for? We are not interested. So sending back does not mean you have accepted a plea bargain. You're saying, well, you want a plea bargain? The state attorney is here. And the state attorney, most likely, after having secured a conviction, is likely to say, no, we go all the way. And they will come back to you and say, no plea bargain. But that puts us in a trap. Does it put you in a trap? You already have the facts. You have already tried the person. You have had all the evidence. The only issue left is sentencing. What is the worst that can happen? If they fail and it comes back to you, would you say you have bias on sentencing? I don't think so. I don't think so. I'm not sure I would find an authority that addresses this issue conclusively on appeal. But as a trial court, what I would do is tell the state attorney, he says he's interested in a plea bargain. Before we go for sentencing, are you interested in the plea bargain? If the state attorney says no, I proceed and I sentence. If they go back and discuss it, because I expect, because after conviction, he's entering a plea bargain anyway, he's saying, I have done it, isn't it? That's what a plea of, the idea of going for the plea bargain is, I have done it. So he's admitting, but after you have already found that he has done it. So I think for me, what would now be the focus of the plea bargain is what Justice Yorokamu had talked about, PJ Emeritus, about sentence bargaining. I mean, sentence bargaining. You're saying, all right, that having been done, me having arrived at the conviction, can you agree on the sentence? Again, that becomes problematic because when it comes back to the trial court, what happens if the trial court says, I am not interested? Can you then go on and impose a sentence that yes, Justice Allen, you are both hands in the air. You want the mic?
My thinking is that if a person says that he wants to do plea bargaining at that stage, it's their right to say it. And if it is their right to say it, then automatically the judicial officer without emotion, an agreement must be an agreement between the state and the accused person. But remember, after those two groups agree, they come to brief the judge. Yes. So if at all the state then says, I am not interested, if you're not in a rush, you can say, I'm going to need 2 minutes. Yes. The state will still come back and say, I'm not interested, you record it, and you go ahead and sentence. I think there would be a technical trap if the state comes back and says, I have agreed. Yes. Because now as a judicial officer, you're caught up in a scenario where the two principal parties are now talking about a plea bargaining, which will be most unlikely where the state has already got conviction. If I was the one, I would say, if you put up your hand, I would say, okay, I'm going to give you a minute. I would say, counsel, when you finish, come and approach me in the chambers, where would ordinarily be discussing those details. And in that way, if in chambers the state says not interested, I come back, record it as there's no agreement, the state is not interested in anything officially, so I'm not delving into the facts. Then I go ahead and sentence. So I think it's about managing your emotions when you're seated in that room, because if the state says, I've refused to do this, and you record it, then you may be caught up in a technical issue. If we ever have a scenario where the state and the defense agree, then there I think we shall get one matter which will go on appeal, and their lordships above will guide us on what happens. Because now you'll have a collusion that you don't know how to approach. That will be a scenario that I'm thinking.
I want us to wind up this because we have another scenario to discuss. But I think what comes out here is that we have had the rules since 2016. And there are certain issues that always come out when you're implementing a law about the practical implementation and the challenges. And I think that's one which stands out. That if you allow them to go and then they agree on a sentence and then you don't agree as a court on the sentence, then what happens? You go ahead and sentence. We should have, Justice Allen will try one and then we will have it on appeal. It will give us clear authority on what to do. But this is what comes out when you're implementing a law and we're discussing the practical applications. Let's have the second group.
It does, because the rules say it should be initiated by the accused person or by the state attorney. The record does not show who initiated this plea bargain. Also, when we look at the record, we did not see any conviction, the court went immediately to sentence the accused person, the convict rather. Also, which should have come before that, there was no process of plea taking as required in Adan versus Republic. The record also shows that the accused said they speak Luganda, but the record does not show whether there was an interpreter or who that interpreter was. Also, the other issue we came up with is that we are not seeing the proper sentencing procedure, so that you have the allocutors and you can get the mitigating and non-mitigating factors. Of course, when we looked at the agreement, all those are captured, but we had agreed that it's better if the trial court refers to them on the record and says this particular provision of the agreement, but it should not be silent. Another issue is that we did not see deduction of the time spent on remand. Additionally, the record does not reflect whether the rights of the accused person were explained to them under Rule 12 of the plea bargain rules. We also noted that the trial court had sentenced and said the sentences would run concurrently without remission, and our position was that remission is not the role of the court or the judicial officer, but for prisons. So we went to now the second aspect, which is to make proposals on the ideal plea bargain procedures. First of all, when we looked at the plea bargain on record, it did not have a case number. The plea bargain agreement should have a case number. That's our first proposal. Also, back to the record, the plea bargain agreement was not formally tendered into court, and there is no record here that shows that the agreement was tendered into court, so the record should actually reflect that a plea bargain agreement has been tendered in. Also, when you look at the plea bargain agreement, it should ideally refer to the provisions of the law. If you look at the charges on page 2 of the agreement, it does not refer to the law, it only refers to the charge, but does not refer to the particular provision. Additionally, the charges do not show the particulars of the offense, and when they're drafting a plea bargain agreement, ideally there should be particulars of the offense contained. The age of the victim, the age of the accused person rather, is also not mentioned. So ideally in a plea bargain agreement, we should have the age of the accused person. The agreement also does not have a victim impact statement, stroke a report from a probation officer. And yet in this particular case, the victim was a juvenile. So this was a gap that we think when the trial court is sentencing, it should have a record of the victim impact statement. Also, the sentencing range in plea bargains should show the maximum, the mid, and the minimum sentence. For the first count, they only referred to the maximum sentence. So ideally, the agreement should have that the minimum and the mid. Also, this particular plea bargain agreement does not contain a pronouncement by the judicial officer at the end about the sentence that they have pronounced. If you look at page 8, it just says accepts the plea and orders that this agreement is incorporated, but there is no pronouncement on what the court has actually sentenced. So that should ideally be there. Also, the plea bargain agreement has annexures, PF24, PF3, but these are marked as annexures, but on the record, we do not have any information on whether they were admitted as exhibits on the record. So this is both a problem, I think, for the agreement and also for the record of proceedings. I think I have handled both.
Thank you. Over to the faculty from my extreme right. You can start with Lillian.
Thank you so much, my Lord. Thank you so much, Your Worship, I believe, for the presentation. You've actually, you have spelled out most of the anomalies that we intended for the purposes of this scenario. It was intended to be a scenario where the agreement was properly filled, but there was no procedure followed from the start because the record doesn't show us anything about the procedure, what transpired in court, apart from telling the person, the accused person, the language, and informing them that they are sentenced to years as agreed. And so it doesn't show that anything was followed, whether plea was taken, whether the rights were explained to the accused person, whether the summary of the case was read, whether he admitted the summary to be correct, whether there was a loquitus, mitigation, all those, it doesn't show. And then the sentencing, whether the accused period spent on remand, nothing. So it shows, it was intended to show that there was a properly filled agreement, save for just a few things he pointed out on the agreement. But it was intended to show that there was a properly filled agreement, but when there was no procedure completely followed. And also about the remission, he brought it very well that remission is not for the court, for the judges, for the judicial officer, but a preserve of prison as per the Prisons Act. So it is wrong for the judges, for the judicial officers to go ahead and sentence and then you say without remission. That one we leave it, the judges leave it to prisons and it is not their role. Then the period spent on remand, like PJ Emeritus has already pointed out, it has to be arithmetically deducted. You tell the person you've spent 3 years on remand and out of 10 you're serving 7. That was not done. Nothing to show anything on the record concerning that. So it is a call upon judicial officers to follow the procedure as it is laid down in Schedule 2 of the rules, because if you don't, can be issues of appeal. It brings the matter to be issues of appeal in the Court of Appeal and the Supreme Court.
Thank you so much, Group 2, for the presentation. It was exhaustive. You talked about the failure to include the particulars of the agreed facts. I wanted to just comment on that part. Usually, in the agreement, you have, when the agreed facts are indicated in the agreement, they should bring out the elements of the offense that you have agreed to. Sometimes when the offense, it's a charge bargain and the offense is reduced maybe from murder to manslaughter, the facts remain as facts of murder. So you should look out to ensure that the agreed facts reflect the offenses that the accused person is pleading to. And also on the issue of participation of victims, the presenter talked about a victim impact statement. In case it is not there, you should look out and make sure that there is some explanation on the agreement whether the victims have been consulted. There is a part in the agreement which talks about any other relevant factors. Usually, I encourage the state attorneys to fill that part to ensure that whatever effort has been done to ensure that they reach out to the victim is indicated in the agreement in case the victim does not show up. Thank you very much.
Thank you, Group 2. Maybe just to add on to the effect of the remand, not taking into account the remand period and then remission. So you're giving more work to the Court of Appeal or whichever appellant court, because that sentence is illegal and the court will definitely set it aside. So make sure that in passing your sentence, take note of the remand period and remission. Then on the issue of the proper procedure of recording a plea bargain agreement, if that is not done, the courts have found that this irregular and set aside the plea bargain agreement. So they send back the accused persons to go for to renegotiate or do a fresh plea bargain. So if we can avoid those, then we shall have really hoped in reducing on the case backlog. Thank you.
All right. Does anyone else want to make a comment from the faculty? DCJ, PJ? All right. Another thing that came out here is that when you are faced with two offenses, there is a joinder of counts. You have defilement and you have aggravated trafficking in persons. People tend to forget that you must agree on a sentence for each offense. That brings clarity. This here that says you are accordingly sentenced as per the plea bargain agreement to 10 years for the offenses of defilement and aggravated trafficking in persons, that's not proper. Defilement, what is the agreement? Because the facts may not be, surely the offense of defilement and aggravated trafficking may not each necessarily fetch 10 years. One could fetch 10, another could fetch 5. Where there's a joinder of counts, the negotiation should be on both, and then the court will determine whether they will be running concurrently or not. These scenarios have been developed for us to pick out the challenges that are commonplace with plea bargains. And you may look at this record of proceedings of Martha Joan of Uganda versus City Danger, and you think it is hypothetical. It is not hypothetical. And I'm sure my Lord Distinguished Emeritus will tell you that they have seen such a record for plea bargain. No plea taken, nothing. Just the court saying, according to your agreement, I hereby sentence you, end of the story. No plea. Total disregard of the plea bargain rules. If you look at Schedule 2, that tells you the procedure to follow. It is so straightforward and so detailed that unless when you're making a plea bargain or finalizing a plea bargain sentence, so it is important to pay attention. The group talked about how did the plea bargain agreement get onto the record. If you look at Schedule 2, the trial court is supposed to find out from the accused person if he's read his rights, he has understood the rights, he has given them up willingly, if he understood the plea bargain agreement, if it was explained to him, and whether he entered it voluntarily, he was not forced to do so. And when you have confirmed it, there is a confirmation form that is supposed to be signed. That confirmation form, I think, is Schedule 1 to the rules. Please use it. Because on appeal, the accused come up with all manner of excuses of what went wrong in the process. And there are some appeals where you will find that the day has been saved by the fact that there was a confirmation form duly signed by the accused person, and he now cannot wriggle out of not having known, not having been told, or that that was not his agreement, because the process would show he confirmed it was the one, he signed, and he was in agreement all along the process. So let's ensure that these forms are filled. I know that it is lunchtime, but allow me to take 8 minutes, just the next 8 minutes, to kind of point out some of the challenges that we face with plea bargains. We have already talked about not taking plea. Adan versus Republic, we can sing it from law school first year. They teach you Adan versus Republic. And in every criminal matter that starts with a plea, Adan versus Republic. It is not an inconvenient procedure or one to be done away with at your discretion when it comes to a plea bargain. It must be followed. Not reading the rights. And I want to say that after a training like this, I'm going to make this admission, one judicial officer came up to me and said, that process of reading the rights is too long, too complicated, that they have decided that they will never do a plea bargain. Yes, this is a fact. That's why I'm talking about attitudes. Yes, and the judicial officer said, so what I do is that I ask the defense and the prosecutors to agree on a sentence, and once I'm agreeable to it, I just do a plea bargain. I just do a plea of guilty. So what starts off as a plea bargain, and the accused knows he's going through a plea bargain, it's negotiated like a plea bargain, but it ends up into a plea of guilty on record. Attitude. Sometimes it is lack of knowledge, but sometimes attitude. Poorly filled forms. Poorly filled agreements. Factual basis is incomplete, does not establish the facts, does not establish the essential elements of the offense. You have no business. If the facts are being read out and the essential elements are not coming out at that point, as a judicial officer, you have no business convicting. Because the essential elements of the offense must be admitted in the facts. We have heard about fraud and collusion in plea bargains, and judicial officers, you need to be alert to this and interest yourself and use the consultation process to the best of your abilities. We were discussing over the tea break all right. We were discussing over the tea break a very popular, not a popular, it was a case that occurred and it was in the media. I think many of us may be familiar with it. A shooting that occurred at one of the malls, I think Quality, in Nalia. The accused was charged with murder by shooting. And a very elaborate summary of the case was prepared by the state that showed this was a murder. If you read the summary of the case, it is the next scenario. All right. They'll present it. But we have had cases where the state and the defense connive and they mislead the court. So unless the court is alert and inquisitive and asks some questions during the consultation, you may be duped into passing a sentence that is improper. Very low sentences. This is one of the criticisms of plea bargain, that we are giving people a handshake and they are walking home So pay attention and make sure that the sentences do fit the crime. We have poor victim representation. I say that boldly, even with the prosecution seated next to me. We have poor victim representation. Victims are not consulted. And yet, if you speak to the victims, you will be passing a sentence that is well informed and which therefore will meet the ends of justice more. It's shocking, but in one of the camps, a victim said, no, the accused person said, but during the negotiations he didn't raise it. But when they were before the court, he said, but I have already compensated the victim. And we thought he was joking. So I put it back to the state. Is it true that he has compensated the victim? The state said, no, I'm not sure, they're going through the file. And he says, I compensated, and she even made an additional statement. But this man had entered a plea bargain. And when we insisted, there was an additional statement on the file. So had the state probably, or had the court insisted, let's hear the victims, or what did the victims say, maybe it would have come out. But clearly you have a situation where this information is being suppressed and may lead to a wrong decision. In another, I've been told lunch is not ready yet, so I'm not standing between you and anything. Okay, I'll hand over to you when I'm done. In one of the plea bargain camps in Soroti, it was a case of robbery. And robbery, you'll tend to think, robbery, grievous harm, the man survived, his motorcycle was recovered, and so they'll come back to you and say maybe 10, 12 years. And when the victim arrived, he had been cut so badly, he had lost the whole use of his right arm. And you see, when you're seeing that victim and you're hearing the impact of the crime and you can see it yourself, you're more likely to give a sentence that fits than one where you don't know what has happened to the victim at all as a result of the commission of the crime. So it's important. Juveniles cannot enter agreements. So they cannot negotiate, sign plea bargain agreements on their own. This is a trouble area. Please watch out for that. I think apart from that, the judge-imposed sentences have been talked about. Those were common, and usually what causes a judge or judicial officer imposed sentence outside the agreement is if you have not made good use of the period of consultation. Otherwise, please desist from it, but it is common. And I think on appeal, these have come through. I'm going to hand over to Justice Wangutusi. He wants to share some decisions on appeal.
Hello. Thank you very much, Chair. What has been going on has been handled by the courts, the Court of Appeal, in several decisions. The decision that really comes up with an elaborate explanation of what is expected in the course of plea bargaining and even taking plea, it will be found in Malinga John Robert.
Us through the presentations. Let's break for lunch. 1 hour, and then we return for the demonstration by group 3.
My lords and your worships, we are going to have a presentation from group 3, but we are waiting for the principal judge to be done with her lunch, since she's chairing the session, so that participants who belong to group 3 should prepare for the presentation. Then we shall have a skit and then wind up the day. But in the meantime, we can be sharing best experiences, what we have learned, especially about plea bargaining.
As we wait for the chair. Any other business? With regard to plea bargaining. I put down here three or four common trouble spots. The first one is trial judicial officers blocking the option of plea bargain when the hearing is still going on, claiming accused has exhausted his chances. We talked about that. The rules are silent on how many times one may enter into plea bargain after the initial attempt. We left it open. So don't be tempted to say you've exhausted your chances. You go for the hearing. Number 2, the trial court not explaining to the accused persons what it means to plead guilty under the plea bargain rules. This one is a common mistake. We assume this work has been done by counsel. But from what we discussed today, it's your duty to do so. So that takes you back to, it was year what, David? Criminal law at the university when you were there. Year 1? Year 1 at the university. Adan versus R. Do you still remember that one? Even if it's plea bargaining, don't run away from Adan versus R. You still have to take plea. You still have to find out whether this person has been forced to sign the agreement or not. You still have to explain those trial rights. The right to fair hearing, the right to keep. You still have to do that. Writing things like, as per, did it one time perhaps, in traffic cases. Those cases can, you have to write the facts, you have to, and when you have so many you are tempted to say as per charge sheet. You have to to state to listen to the facts, ask questions, are done versus are. I want it to ring to your mind until you get it right. But then what we are talking about is okay if you are a new magistrate, or if you are, even when you are a new judge, it's okay. But for a senior judge, someone who has been in the system for more than 3 years, to do the sort of thing we have seen today, I think next time we should disclose the names of the judges. Yes. Because when we were in Igulu, we took JTI staff to task. He said, no, these are hypotheticals. These are hypotheticals. He said, no, these are real decisions of judges. Something you can't believe. So, do you know some of these things are finding their way into the URI? A decision like that one, it is reported, and people in Canada, people in South Africa, no. Let's abandon this type of work. Let's be serious. And I choose the bargain rules about his or her constitutional rights to a fair trial, and confirm that his plea or her plea, that's it. Are you sure you've agreed to serve 20 years imprisonment? I'm aware. But if you can reduce it, so much the better, but I'm aware. Were you told that you don't, you can insist on being tried? Yes, I find out whether someone talked about those things. Don't assume. Any other trouble spots one can think of? Any other? We talked about the period spent on remand. We are the people who started that debate. I remember handling a session in Movende, and when I was sentencing, I said, I hereby sentence you to 15 years imprisonment, period spent on remand inclusive. And I was criticized by Court of Appeal. But as time, I'm not alone. Even people are still doing it. By then we had no guidance. By then we had no guidance, no training of this nature. It was not there. But now you have opportunity to be trained by those who have made mistakes. And you are now, I will be now that we've talked about it, I will be visiting Yuri every now and then to find out who is doing what. Hey. I had wanted to look at your judgments. I wish you had brought us some of them. Tomorrow we are starting on, you have some judgments? Hey, let's have a look. Now that we are starting on judgment writing tomorrow, let's have a look before we start on the subject. You will be surprised. Huh? But judgment writing is for tomorrow, so let's wait and see. But for the period spent on remand, deduct it. Court of Appeal will not get an appeal on a sentence from this region, now that we've talked about it. Right or wrong? Oh, wait. The idea is that the law requires that sentences are to commence from the day the sentence is imposed. That's the justification. So the moment you say period spent on remand inclusive, you are vague. You are being vague. You have to take into account the period spent on remand. And how do you take it into account? Deduct it. And how do you deduct it? Very easy. The prosecutor will tell you. The accused person may have forgotten. Those people keep records very well in prison. So they will say he entered on this day, and even the minute is recorded. And then your duty is to deduct 13 from 27. 13 years. Surely, why do we get it wrong? Okay. Who is the chairperson? And we start. Mm-hmm. Is the group ready for the skit, for the presentation? Well, can we get the stage ready for the presentation? You are the chair? You are counsel? We have our presenter. Yeah, the presentation. For the, yes.
Justice Allen and the company are supposed to do a demonstration from commencement of the negotiations up to sentencing. And that's the IT group since yesterday. Mr. Atoke, maybe you chair as we wait for. No, but the acting PJ doesn't have to. Yeah, let's get a chair.
Actually, she's not there.
Ah, okay. Oh, well.
So there was a small presentation of number 1 and number 2, then number 3 was the skit.
Yeah.
So it's just going to go through number 1 and number 2, then the skit. And then we do the skit.
Do you need to set the stage? Uh-huh.
Okay. Thank you, my Lord. My Lord, this is Group 3. And I'm starting with part 1 of our question. We're given facts, a court file, and we're asked to identify the gaps from the court record. So we perused the record, and we found a few gaps that were not followed in the process. The first gap we identified was that the plea-taking process was not properly done. This has been well emphasized here. We have looked at Adan versus Republic. There was no indication that the constitutional rights of the accused person were explained to him as required under Rule 12 and the second schedule to the rules. Then the facts before the conviction were not captured on the court record. So these facts were not explained and not on the court record that was available to us. Then there was no indication from the facts that the victim's family was consulted. Also, the plea bargain agreement was not introduced before the court and confirmed. We have looked at the process of how the plea bargain agreement gets onto the court record, which again was not followed. So the defense did not as well confirm the plea bargain agreement before the court entered the conviction and sentencing of the accused person. This agreement was not explained to the accused person before indeed the conviction was entered. It is not clear whether even the accused person understood the charge or the repercussion of the agreement that was being entered before the court. Then there was no indication from the record that the trial judge considered the aggravating and mitigating factors before sentencing. When you look at the facts, the judge simply, after the state introduced the agreement, went ahead to sentence the accused person without referring to the aggravating and mitigating factors. So the amended charge sheet that was also referred to by the prosecution, we see from the facts that the prosecutions or the state came and informed the court that we have reduced the charge from murder to manslaughter. But when you look at the indictment, it shows murder. So there was a gap in that the judge went ahead and convicted and sentenced the accused person on a charge of manslaughter, whereas the indictment read murder. Then there is a point, should the judge have simply confirmed the amendment of the indictment from murder to manslaughter when the facts strongly pointed to an offense of murder? Now, when you look at the indictment on the court record, it even gives ingredients with forethought. But here the state comes, or the prosecution comes and informs the judge that we have agreed to reduce the charge from murder to manslaughter. And the court actually allowed that amendment. So we found a gap there in that the court, despite the existence of strong ingredients pointing to murder, the charge was reduced to manslaughter. probably it was some kind of connivance between the prosecution and the accused person, but also the court was misled into allowing that amended charge, whereas there was evidence of murder. So when we came to the proposals on the ideal plea bargain process and the procedure, we slowed down to Schedule 2 of the plea bargain rules. So we looked at the anomalies and came up with how we could remedy them, referring to the rules. So we saw that the party ought to have been called, representations are made, the parties are introduced, the prosecution introduces the plea bargain agreement as per Rule 5 of the rules, which is confirmed by the defense. Then the court informs the accused of his or her rights in a criminal trial. These rights have been explained very well by the previous speakers. Then the court has to find out from the accused person whether he or she voluntarily signed the plea bargain agreement after it had been explained to the accused person in a language he or she understands. Then if it is confirmed by the accused person, he is invited to execute a confirmation of that agreement. If the agreement is accepted by the court, the same is received on the court record. So that's when the charge is read and explained to the accused person in the language he or she understands. Wow. My Lord, that's all we had for our presentation. We shall now have the skit to demonstrate the plea bargain process from the negotiation to the time when the accused person is convicted.
So are you moving in front here? We're in Mbarara, we are the hosts. Shall we create a courtroom? Bring it here. Where is the defense lawyer? It's there.
Do you have the charge sheet?
There.
First check on those things.
Probation person? So for you, why? You're the father of the victim. Our suspect is there in a hijab. So
So here we are still in chambers now before we become a courtroom. And the lawyers have come to see me because they were having a negotiation there.
It's here.
So now they have come to the
May it please you, my Lord. We've come to meet you. We've had a meeting with the accused person and his advocate. No, we are in chambers. I was assuming that my Lord already knows me.
Okay, I think.
May it please you, my Lord. May it please you, my Lord. My name is Nasuna Sharon. I'm a chief state attorney. My land friend, Ms. Tabaruka Rachel, is the advocate for the accused person. My Lord, we've come to brief you about the accused person. We've had a meeting and we've agreed to a sentence of 24 years for the charge of murder, and we've agreed to an imprisonment term of 24 years. My land colleague can also address you on that.
My Lord, as I've been introduced by state, I represent the accused person. I met with the accused person after him informing me of his interest in enrolling for plea bargain. I talked to him, explained his rights. After we met with state, and then we agreed, we went back, informed him, and he also agreed to sentence of imprisonment for 24 years imprisonment for murder.
Which case is this? Is this Achiro, the one of Semakula? Which case is this?
My Lord, this is the case of Achiro,
Can I have
which
a
is
look
charged
at
with the offense of murder.
Can I have a look at the indictment? Because I know you're the one who has the police file. So briefly, what are the facts? I need to understand before I can determine if it's something I would be able to agree to. So what are the
My
facts?
Lord, this is an incident that happened at after a scuffle. He was 24 years old.
Defense, that's the position?
Yes, my Lord.
So you've agreed to how many years?
24 years.
24 years. Have you consulted the victim's family?
We've had
And the community? Have you consulted the community?
we've also had probation social welfare officer, and they gave us a briefing about the impact of the sentence on the community, and they were also in agreement with the sentence. They think it is fair.
So does he know that he's going to participate in a plea bargain? Have you explained to him his rights? Because I don't want a scenario where I appear and then he starts saying he doesn't know. I'm a very busy person. I also don't have time.
My Lord, I've explained to him his rights, and he has agreed, and he understood the rights, and then he willfully entered into plea bargain.
It is this one here who was standing, the woman. You're calling him here, I'm wondering. That's the one. Anyway, so do you have the agreement? I can have a look at it.
My Lord, this is the agreement. We wish to present it.
Where was that agreement?
We had the agreement.
It was attached on the... But I can see you haven't ticked here to show that you explain the rights. So in as much as you explain, I think you need to tick to show that you've done that. Has the accused person signed as well already?
Yes, my Lord.
And this summary of the facts that you've written here, we agreed upon by both of you.
Yes, I read them back to the accused and the accused's advocate.
Okay. The agreement seems signed. I think 24 years is not bad. The minimum in the sentencing guideline should have been 30, but since it's a plea bargain, I think we can take 24 for murder. I'll find it, I think, it's a bit acceptable. Let's present him and see how the matter goes.
Much obliged, my lord.
Much obliged, Your.
So you go back, then we go to open court.
We are now in open court?
Before we proceed, could we share some remarks about the opening, that consultation? Does anyone have any observation? I know Justice Wangutusu gave a very big hand clap. I don't know if... Yes, you could tell us why you have given a hand clap. Yes, but you want to say something?
Thank you, Chair. I made an observation that the group had not had departed from the facts that were in the script. Because I'm saying that my observation is that the group departed from the facts that are in the script, because you're talking about a murder case, and yet the script talks about a murder that has been amended to manslaughter and a sentence of 10 years given. Yes, that was my observation.
I think we can adjust accordingly, but I think we are guilty on that point, because after highlighting item number 1 and 2, and we saw that there were mistakes, and we had been told we are going to go there to sentencing. If it comes as it is here, I will obviously reject the whole issue of manslaughter on the basis of the facts. So I don't know if that's what you wanted. Yeah. Oh, okay.
Everybody has the scenario, and could the people who developed the scenarios that you were hoping to see to be demonstrated, and what it was that you think?
Thank you, Chair. Our expectation from murder, reduced from murder to manslaughter.
Come back. Come back. Come back and consult properly. You can present.
My lord, the appearances as before. Okay. Okay. My lord, the accused person was initially charged with the offense of murder. However, upon reading through the facts and the statements, we've amended the charge sheet, and we are charging the accused with the offense of manslaughter. And upon agreement with the accused and the advocate for the accused, we've agreed to a sentence of 10 years imprisonment.
Defense, is that the position?
That is the position, my lord.
Okay, can I have a look at the indictment and the summary? Is this a case of, you say it is of who? Achiro? Achiro. Appeal. What are the facts in this matter?
The deceased was shot dead. The deceased was shot dead during a... Yes, there was a gun, and the same was exhibited.
It hasn't yet been exhibited. It was taken for police. a trolley, the trolley was pushed, it in a gun, come back and act on it. I don't understand the basis upon which you considered to drop the matter to manslaughter. Have you considered the ingredients properly?
My Lord, I considered all the ingredients. And to my conviction, we wouldn't secure a conviction under the charge of murder.
You think the DPP will be comfortable? Because I see these facts seem to portray all the ingredients of murder. I think it may be, is it a matter you've really consulted and considered seriously?
My Lord, I did, but we can go with your guidance.
With my guidance, now you'll be making me the person negotiating. But anyway, just to be very clear, I have looked at it before even I get into the plea bargaining with the accused person in open court. I think I would be very uncomfortable if these were the facts. Because if you consider the ingredients of murder, you have aspects of manslaughter, malice aforethought, that there was a person who was already killed, which is confirmed, that it was unlawful, and participation. So the whole idea of going back, picking a gun in a scuffle, coming back, there's no evidence to show here from your summary that you wrote that the other person was armed or there was need to use such excessive force. But going to pick a gun and coming back and shooting, I think it may not be, it's against public policy. It will look very unreasonable for us to go and drop it for manslaughter. It is not a befitting case to change the offense from murder to manslaughter. So I think you may have to go back and renegotiate, because it would be improper to drop it to an offense whose ingredients are not reflected in the summary of the offense.
Must obliged, my Lord.
So go back and consult on that issue. You consider it my guidance to you as a state, then you can come back.
Spot on. Spot on. I think that really is what they were looking for. I see them looking like some satisfied pussycats. Yes, I think that really is the interrogation during the discussion, and being satisfied that the facts that are being presented do suit the offense for which the person is charged and which the agreement is being made. And if indeed it is a manslaughter, then they ought to be able to convince you that there was no malice. And to say there was a scuffle is not sufficient, I think. The facts are important. I think the facts that led up to the shooting are important for you to understand whether there was malice aforethought or not. But that exactly is the discussion that we expect to take place. My Lord?
I just noted that the judge has not commented on any sentence he would consider appropriate at this stage. He's leaving it to the state attorney and defense counsel. Well done.
Okay, before we take leave of the matter, somebody has a comment at the back? Let's take that before we proceed.
I hope you're consulting now, then you're about to come back. Yeah. Now you should be alert properly.
Thank you so much, my Lord. I don't know whether we shall also consider the first scenario where we talked about the victim impact. Okay, because I thought by the time you were asking about the facts of reducing the charge from manslaughter from murder to manslaughter, I thought at that point you would also have inquired from the state whether they found out from the family of the deceased whether they were comfortable with having the charge reduced to manslaughter.
I think the first presentation we did, we deleted and we replayed again. So we are now starting afresh. And I didn't get into that one because from the onset you have a problem with the facts, the ingredients being shown. So whether the family agreed or not, it may be a bit difficult for court to say that because the family has agreed, I go for manslaughter. Finally, if the matter ends up in the Court of Appeal where they are much more wiser people, They can eat you up as a judicial officer and wonder how you even went ahead because the family agreed. That's why we didn't get into that point of discussion. Yes, Your Worship?
Regardless whether it's manslaughter or murder, my inquiry is still, I know the rules provide that we need to consult with the victims and the family and all those things. But there is a part, in the first script that we deleted finally because the judge was not very alert. The state and defense counsel were submitting that they had contacted the family and they were agreeable to the sentence. Now that's where my question is it them that are supposed to be agreeable, or is in the agreement just between the state and the accused person, but their input is just to guide? But if they said they didn't like the sentence, then would you now say there is no agreement? That is not for the judge here, for the faculty. Would there not be an agreement because the family maybe wanted more of compensation and this person is saying we don't have money, and so I am more willing to serve a term of imprisonment without compensation? So then does that change anything, or then the state would say there is no agreement because the convict now cannot afford compensation and is not agreeable to compensation? That is really for the faculty.
I didn't want to disturb the chairperson. With your permission, Chair. I thought that's a matter faculty will answer when you have a plenary. If we would be allowed to finish a skit, because my lawyers are standing and people are here, so I would prefer we finish and we also sit there, then we ask questions also. Then it can be written down. Yeah. Okay. But so it's up to you.
Your question has been noted and we will come back to it. Let's now proceed to the skit itself.
My Lord, the lawyers are here.
Okay. Now you're back with Madam. No, she was here earlier on. So you can say you're back.
May it please you, my Lord. My name is Nasuna Sharon. I'm a chief state attorney.
You were here earlier when I'd sent you back. So have you had another negotiation?
We've had another meeting with the accused person and the advocate for the accused. And we've now agreed to a sentence of an imprisonment term of 24 years.
On what offense first? Because
This
my
is
first
the offense
problem
of murder.
Murder.
We've maintained the earlier charge of murder.
Mm-hmm.
And we've agreed to a sentence of 24 years imprisonment.
24 years imprisonment?
Yes.
You're sure the accused has accepted 24 years on offense of murder?
We've engaged the accused.
My Lord, we've engaged the accused person. I talked to him, and he is agreeable to the punishment, that is 24 years imprisonment.
24 years?
Yes, my Lord.
Have you explained to him his rights?
Yes, my Lord, I explained his right.
Like which one?
I explained to him that once he pleads guilty, then all his constitutional rights of her, being presumed not guilty, fair and full trial.
You see, that is what I was saying. You told him that you told her that she's innocent until proven guilty.
Yes, my Lord, I explained to that.
You also told her she's entitled to a full trial.
Yes,
where
my
they
Lord.
can call witnesses.
Yes, my Lord.
And they'll be given a lawyer.
Yes, my Lord.
So they know that if they participate in this plea bargaining, it means that all those rights are waived.
Yes, my Lord.
You're sure you told her that?
Yes, my Lord, I did.
Okay. Has she signed the agreement?
My Lord, we have the agreement.
Let me
It has
have a
been
look.
signed by the accused person.
Do you have any other report from the community or anything like that?
We have a report from the probational social welfare officer.
The community impact statement?
Yes.
You have it here also?
It is here, my Lord.
So the probation officer is saying that the crime affected the community and the young man was killed.
Yes, my Lord.
Okay. Who else have you consulted?
We've also consulted the relative of the victim. And they are also agreeable to the sentence. They think that it is fair and it will serve justice.
Okay. I realized I think everything has been filled in. You wrote down the aggravating and mitigating factors?
Yes, my lord, they are indicated.
Okay. It seems everything has been signed. I think I'll find 24 years, I think I'll accept. I'll find it acceptable. We can go ahead with plea bargaining then. So let me come to open court and then you present the accused person.
Most obliged, my lord.
I hope prisons brought them.
They did.
Yeah, you tell them to bring the person up. So doc, let me come in.
Criminal session, criminal case number 5. Are you coming? Just come in the court. Can the accused sit here? Where is the accused going to sit? State, come and sit.
You sit next to her.
Criminal case number 557 of 2024, Uganda versus Apio Lucy.
Prisons, you've handcuffed the accused person? Okay. Yes, state?
May it please you, my lord.
Representation?
Nasuna Sharon, Chief State Attorney. For the defense, we have Ms. Tavaruka Rachel. She's the counsel for the accused person. My lord, we have the accused person before court. And we are ready to proceed with this matter. My lord, we've met with the accused person. We are presenting the accused person on a plea bargain. And having sat and agreed, we are presenting him. And we have agreed on a sentence of 24 years imprisonment. The accused person is charged with the offense of murder. If it pleases you, I pray to present before court the plea bargain agreement.
Okay, before we move on, my clerk is, what's her name? Achigo Helen.
Yes.
So you'll also work as the interpreter. Accused person, what's your name?
Apio Lucy.
Apio Lucy. What language? What language do you understand? Okay, I'm being told by the state that they have presented a plea bargaining agreement and there has been an agreement. So defense, is that the position? Defense counsel?
Yes, my lord, that is the position.
You have reached a plea bargaining?
Yes, my lord.
On the offense of murder?
Yes, my lord.
And a sentence of how many years?
24 years, my lord.
Accused person, you said you know English?
Yes, my lord.
So they are saying that you have agreed to a plea bargaining agreement and you have entered into a plea bargaining agreement for the offense of murder and reached a sentence of 24 years. Is that the position?
Yes, my lord, but I did not understand something.
You didn't understand something. Okay, what part didn't you understand? The offense, did you agree or you didn't agree?
Yes, I agreed.
You agreed to a plea bargaining agreement?
Yes, my lord.
And an offense of 24 years?
Yes, my lord.
Okay. State, did you, defense, did you explain to her rights?
My lord, I did explain to her the rights.
Okay, what part exactly didn't you understand, accused person, so that we can clarify it?
I wanted to be sure if I was going to be given the 24 years.
Okay. I'll explain that. In plea bargaining, if you've had a negotiation with the accused, with the state, and they have also included the victims, and you've agreed on a sentence, if court finds it acceptable, then you'll be given that. Court cannot reduce or increase anything in the plea bargaining agreement once it has accepted the years. So once we go through the procedures and that's a position, yes, you'll get those 24 years as you agreed. Nothing more will be reduced or added, apart from deducting the period you've spent on remand. Is that the only part that you wanted to understand?
Yes, my lord.
Okay. So I think, the what? You wanted to say something, counsel?
State. Had tendered in the plea bargain agreement. The clerk has it. I pray that she presents it to court.
Before it is presented, let us first go through the rights. I have to explain to you. First of all, the offense you're charged with, which is murder, the ingredients there are that there was a person who was killed, that the killing was unlawful, it was not permitted by any law, that there was a malice aforethought, basically it was not done in good spirit, and that you're the one who did it. That is the offense that is being brought against you. Have you understood that part?
Yes, I did it.
Now, I'll explain to you your rights also. As you enter into this plea bargaining agreement, ordinarily, you're entitled to a full trial. And in a full trial, if you can't afford a lawyer is given to you, and that lawyer defends you, paid for by the state. You also presume to be innocent until you're proven guilty, and you're also entitled to just keep quiet if you wanted, without saying anything, so the state has got to prove the other ingredients talked about. Once you enter into a plea bargaining agreement, it means that you're going to be convicted now and sentenced now, and those rights, for example, of going for a full trial are waived. You will not have a right to a full trial. Have you understood those rights?
Yes, I've understood, my
And your lawyer also explained them to you?
Yes, she did.
Okay, so you willingly waive those rights that you have and prefer to have your matter heard now and you're convicted and sentenced?
Yes, my lord, I'm tired of being in prison.
Okay. You've also understood the nature of the offense that I explained to you?
Yes, my lord.
And you know that it has a maximum sentence of death penalty, but we shall go with the years you have agreed with the state?
Lord.
You have also
Yes, my
agreed. And has anybody forced you?
No, 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 no.
Have you been coerced by anybody or scared?
No, I'm not.
Okay. Did you sign the agreement?
Yes, I did.
Can you show her the agreement? Did you sign the agreement there? Is that the agreement you signed?
Yes, this is my signature.
That's your signature?
Yes, my lord.
Okay. So for my record here, as I was writing my confirmations, I'm going to write here that you've accepted that you signed a plea bargaining agreement that has been brought to me, and you have agreed to an offense of murder, in respect to offense of murder, and a sentence of 24 years.
Okay, my lord.
So, state, can you sign here to confirm? Defense, and give your client to also sign. That confirms that you signed a plea bargaining agreement in respect to the offense of murder for 24 years. Okay, now we are going to go to plea taking, so I would request that you listen very carefully. Clerk, can you read to the accused person the charge?
Yes, my lord. Appeal Lucy, you're being charged with murder contrary to section 188 and 189 of the Penal Code Act. The particulars of your offense are Appeal Lucy on the 9th day of July 2019 at Quality Shopping Village, Nalia, Namgongo Division, Chira Municipality in Wakiso District with malice aforethought unlawfully killed Ainebiona Arnold.
Have you heard the charge?
Yes, I have, my lord.
Is it true?
Yes, it's true.
What is true?
That I killed him.
Plea of guilt is entered. State.
My lord, these are the brief facts of the case.
Accused, you listen. They are going to read for you the facts of the case, so you listen attentively.
On the 9th day of July 2019 at 10 o'clock, while at Nalia Shopping Village in Namgongo, which is within Wakiso District, the deceased was shot. His death is proved by a post-mortem report, which is Police Form 48, in which Dr. Mutumba confirmed that death whose cause was gunshot wounds. The post-mortem report still shows that the deceased was shot, and there's no indication that this was authorized by the law. The commission of this offense was witnessed by several witnesses who all indicated that it is the accused who shot the deceased. The case was reported at Chira Division Police Station. The accused person was arrested, examined, and found to be of normal demeanor and of sound mind, and he was thereafter charged with the offense of murder. My lord, we now humbly pray to tender in Police Form 48B, a post-mortem report, a report from the Government Analytical Laboratory, and also Police Form 24.
Okay, let's first go into the confirmation of the facts. Accused person, have you heard those facts?
Yes, I have, my lord.
Are they true?
Everything she said is true.
Okay, you are accordingly convicted of the offense of murder on your own plea of guilt and a plea bargaining agreement. So the documents that you wanted to tender in defense, you have any objection?
No objection, my lord.
So I put on record the Police Form 48, the post-mortem report, and the document from the Analytical Laboratory girl as PX1 and PX2 respectively. Aggravating factors?
My lord, in aggravation, the deceased was a 26-year-old with a hopeful life ahead of him. The convict cut this life short unjustly out of ego. He shot the convict ruthlessly, and by his acts, he presents himself as one who is not fit to be in society, but rather deterred. There's also need to send out a message to other would-be offenders to understand that crime is heavily punished. As prosecution, our conviction is that a custodial sentence of 24 years imprisonment is most appropriate. My lord, before court we have the probation social welfare officer to represent the interests of the community. We also have in court the relative of the victim. We pray that their views are taken into consideration before the agreement is endorsed by court.
And mitigating factors, I'll consider them after that. Counsel?
My lord, the convict is aged 35 years. He's still in his youthful stage. Thus, he can easily be rehabilitated. He had a young family with 5 children, and he's a sole breadwinner. He is remorseful by accepting his actions. So, my lord, we pray that the 24 years be confirmed by this honorable court.
Okay. Now, may I hear from the probation officer? You said you have one? Yes. Do you have the community impact statement?
My lord, Natrinda Rita is my name. I'm the probation and social welfare officer. Actually, I consulted the local authorities and also visited the deceased's family. The accused person, now the convict, is a violent man, and he cannot control his temper. Actually, the community wasn't shocked that he is the one who murdered the deceased. The report is with the state attorney. My lord, that's all with the probation and social welfare officer.
Okay. And you said you also have somebody from the victim's family?
My lord, we also have the mother of the deceased.
Don't cry. Can we give you some water? Yes, let's have silence in court.
Yes, they killed my son. She killed my son. My son was very young, and he had just finished school. He didn't leave me any grandchild, and I have no one to look after me. And whenever I am sick, he used to take me to the hospital. Now I have no one. But the state talks to us as a family. So we sat down and we feel like the punishment is okay. He deserves it. He should go to the prison and also suffer there. Yes. We have buried our son, and we have no one now. Our son is dead, and there's no one to replace him, and we are still really grieving.
We sympathize with you. Thank you so much. Can we also hear from the accused person if you want to say anything before your sentencing?
My lord, I have accepted my offense. I have had time to reflect on what I did. I don't know if court can allow me to talk to the mother of the victim. I wanted to apologize for what I did.
You can even apologize now.
I am sorry for what I did. That is all.
Okay, we're going to go to sentencing. Prisons? Where's prisons? Yes, how long has she been on remand?
My lord, the person was admitted here on 23rd of February 2024, which makes it 1 year and 6 months on remand.
So when you deduct that from 24, what do you get?
My lord, you get 22 years and 2 months.
20 what?
Well, you get 22 years.
Mm-hmm.
And
6 months.
6 months.
Okay. So in sentencing, I have the plea bargaining agreement that was presented. I have endorsed it since all the parties are in agreement. And this is my sentencing. I have considered the aggravating and mitigating factors that have been put forward by the parties. And I find the year that was agreed in the plea bargaining agreement of 24 years to be suitable in the circumstances. I deduct the period that the convict now has spent on remand of 1 year and 6 months, according to prisons. The convict will now serve a sentence of 22 years and 6 months, starting from today. The convict is advised that they have a right of appeal against conviction and sentence within 14 days if they so desire. So that is a sentence, yeah.
Most obliged, my.
Thank you very much, Judge Allen. Could I ask the developers of the scenario, are you satisfied? Do you have any comments to make?
Thank you so much, Group 3. On my part, I'm satisfied. Just a few things like the procedures, but there are many ways of skinning a goat, as long as you achieve the aim at the end of the day. So thank you.
Thank you so much, Group 3. I believe it has been well done, and I just wanted to emphasize the importance of victim consultation. It helps with the healing process of the victim, and also promotes fairness and transparency. However, when the victims are not consulted, it negatively impacts on the justice system and also can increase on incidences of mob justice once the accused comes out. So it's very important to consult victims. And sometimes you may consult a victim, and actually once they see that the accused person is taking responsibility and owning up, I've had instances where they even plead that we should reduce on the sentence because he's remorseful, and that is the whole, importance of victim consultation. It promotes reconciliation. So it's very important to consult victims. Thank you.
Thank you so much, Group 3. Thank you so much, my Lord. Also, just wanted to add on victim participation. And I want to say it is real. It is real in that, like she says, in a way it promotes reconciliation and healing. If I can give an example, we handled a matter in Gulu, where the victim was crying, the mother was crying, the accused cried, the defense lawyer was a lady. I looked at her, she was crying. I think I also almost I looked at this male judge in this angle, but apart from the judge and the clerk, but it was so emotional. It was so emotional by that, but by the end of that reconciliation process of the accused apologizing and everything, by the time they left court, they had healed a bit. They were not crying anymore. And we believe that that entire process helps them to heal. And even recently, we handled a matter where one of the victims was as if strong, but when the judge requested her to respond to what the accused was saying, that he was praying for forgiveness, she broke down. And it was emotional, but at the end of the day, they told me at least they're happy. The victim had achieved justice, and they were happy by how the entire process was done. So it helps in healing and reconciling the victims. Her worship, I don't know her name, she talked about what if the victim is not agreeable with the sentence. Your worship, the rules require for victim involvement, but the state prevails over the victims. We represent the victims, and the matter is Uganda versus the accused person. So we involve them, and we take them through what is going to happen and what happens in the process of plea bargaining. And as a result, if you noticed in case scenario number 2, in there, among other factors, we noted there that the victim's mother was okay with 7 years, but the record was showing 10 years. Meaning, much as the victim's mother was okay with 7 years, but the circumstances of the case, we prevailed and we found 10 years suiting for the case. So even if the victim may tell you, maybe they release him, but you committed an offense, and he has to be punished for that. So we prevail over them, and we agree on a reasonable sentence given the circumstances of the case. Thank you.
Okay. Judge Allen, you had something to say, if you could.
Nothing much, really. We had also shared, as we were doing the research, we had some cases that were guiding us. I think some also came from the faculty with retired Justice Wangutusi, because they highlight some of the points, what I had put up there. I think recently when we had a plea bargaining, if I'm not mistaken, my Lord PJ, when you came, when there was that decision, I think from Court of Appeal, about informing the people about the ingredients of the offense. And also given that sometimes we forget to write that confirmation at the end. For me, as a matter of practice now, when they finish saying that, yes, I signed the agreement, and the defense says it's true and the accused, I make them sign. We sign a confirmation on the same record. I confirm that we have signed the agreement, the plea bargaining, then we go into plea taking. So that it's on record itself, because sometimes that confirmation that you have at the end may it mysteriously be missing from the record when the record is taken to Court of Appeal. And when it's in the typing itself, it may not be there. It may have to be there. So you may have to tactfully find a way of handling and doing that. That's what I do personally. But each person can get their own style on how they do that. So some of those cases we highlighted that I've got that you can also go and do the reading. Those are the main points that they highlight in those cases here.
Thank you so much. There was a significant point when the accused person said, yes, I'm tired of being in prison. I'm tired of being in prison. Usually that should be an alert, a red flag, and you need to inquire. Are you pleading guilty because you're tired of being in prison? You may be shocked that when you ask that question, the person will then melt down and say, I didn't do it, but how long am I going to wait? It happens. So once you hear that, I'm here for too long, I have been here for too long, I want to be attended to, you need to make an inquiry in that arena, because that's one of the biggest criticisms now of plea bargain, is that the inmates are signing up for it because they are actually tired. Again, one of the things to look at critically are the facts, the ingredients of the offense, interrogating the facts that have been presented so that you're sure that they connect the accused. There are interesting scenarios where when you interrogate, you dig out something else. We've had victims appearing before us, especially in the camp in Gulu, accused persons, and they have entered plea bargains for about 10 years, 8 years. They don't bring up the issue of age. I don't know why. I don't know if they bring it up and it's ignored. And then when they come in court, put up their hand and say, I was below 18. And when we interrogate, it is shocking that you would find charge and caution statement, 17 years. Some even have a police form that shows 17 years. So how did this person enter into a plea bargain for 8 or 10 years when they committed the offense while they were juveniles? So the need to critically look at the facts cannot be overemphasized. In Masindi, one of the accused persons had signed up for a robbery, aggravated robbery. And he kept making those indications of, I'm tired of being here. And so I thought to interrogate him a little bit more about the facts. And the man didn't have the facts that the state was talking about. And when we shared with her, I said, I think you need to go and look at this file again. I'm not sure that the evidence points him out. When she came back, she said, actually, the evidence does not implicate him. But he was tired, and he had entered into a plea bargain for aggravated robbery. So the trial judge, the trial magistrate has to be alert. You have to be alert, you have to interrogate the facts, and make as many inquiries as may assist you in ensuring that justice is done. My Lord Justice Wangutusi, you have something to say?
There are people who are attending online, and one of them has sent a question. And the question, there are two. One of them, thank you so much for this training. It is very educative. I am following the discussion on Zoom, just seeking guidance on the sentencing guidelines vis-a-vis the case of Sande versus R. how best can we handle that too? I don't know the case that is being referred to, so. You should say something. Yes, now the other one is, in my opinion, this is Akusia Joseph. In my opinion, plea bargain should be abolished on murder charges because the deceased cannot come back to life to negotiate justice for himself. Because not even the family members can decide what best suits his interest. I think the interest of the deceased. Now this one, I just, in my view, I would like to re-emphasize that that deceased is not a party to these proceedings. It is the Uganda versus the accused person. That's the thing, because even without plea bargaining, he won't come. So unless you have some, there's a faculty, maybe you have something you can say about it. But for me, I really don't have.
Well, I'm very glad to have the feedback from those that are following online, and we appreciate the questions that you have asked. I'm going to ask Susan Wakabala, who seems to have encountered Sunday versus R. Sunday versus R? Uganda versus?
Thank you, my Lord, the PJ. If I remember scantly, that decision, is it, I don't know whether it's declaring or outlawed the constitutional, the sentencing guidelines. But however, the DPP put in an application and it was stayed. Yeah. So right now, what I can say is that the sentencing guidelines are still lawful, pending the determination of the court. Yeah.
You see, the trial judge in the plea bargain, all those cases said should record and sentence the agreed sentence. So the trial judge in a plea bargain would not be involved in following sentencing guidelines. So I don't think that is relevant. So what I would want really to recommend is, first of all, commend Justin Shimi and his group for putting together all these cases. There are many more. I think before you go for plea bargain, it would be useful for you to have the rules, the instrument on the side. Study these cases and simply follow them. After some time, you will gain the experience. You saw them when they were explaining the rights to the accused person. It doesn't take so long, which was the worry of one of us who confronted the principal judge. It doesn't take long when you follow them. We used to have those problems when we were recording confession statements. But what we would do is you get the practice guidelines by Justice Wambuzi, put them on the side, and follow them strictly as they are. Over time, you acquire the experience and it becomes easy. If you don't follow the rules, let me observe that most of the mistakes that you are looking at are from very senior judges. It's not, in fact, the new judges. It's the very senior ones. The mistake is from assuming that you know. And then you start doing what you used to go to do some time ago. But the rules are new. And you may not recall all of them. So indeed, keep these authorities as your guide, but keep the rules near you and keep checking. Have a checklist, what not to do. The mistakes that are being pointed out, why do you have to repeat them? Let's learn from these mistakes, and it shall be easy for us. Thank you very much.
Thank you, my Lord, DCJ Emeritus. Is there any other observation, question? Yes, my Lord.
Just to say thank you, PJ. The guidelines, the sentencing guidelines do not apply to plea bargain cases. The sentencing guidelines were flagged off in 2013 and plea bargaining was in 2016. We were of the view that for plea bargaining to be successful, we would have guidelines tailored towards that one. Guidelines for plea bargain cases. By the time I left the judiciary, that was something we were thinking about. So it is still something you need to think about. So that other chap online should not confuse the two. Guidelines do not apply to sentencing, but it's a guidance. That's what since we are looking at consistency of sentences, and we can't run away from that one. But we need time to look at guidelines in plea bargain cases.
Thank you very much.
Just to give information.
Yes.
Before Justice Bamwine retired, we worked on them with him and a committee. After his retirement, they were presented before the Joint Committee of the Rules Committee and the Judicial Reform Committee. They were approved. I'll be following up with the First Parliamentary Council to have them issued. Yeah.
Okay. I think what has been quite instructive is having this in mind, that if you're dealing with a murder, what is the sentencing range after full trial? And I know that many of the parties would consider and say, for an offense of this nature, almost similar facts, the Supreme Court, the Court of Appeal have upheld sentences within this range. Give the accused person a little credence, or can I say a little benefit for having accepted the crime at the beginning. So if this was full trial, we would be looking at maybe 30 years, 25 to 30. Under a plea bargain, therefore, if we discounted, then we could give him about 20. I think that generally has been the way that the prosecutors and the defense lawyers have settled. And I think it applies for all manner of offenses. Your Worship, earlier in the morning, you said something about a form. That form is not law. It is not part of the rules. It was just developed by EDJTI, myself, the DPP herself, and the resident judge then, senior resident judge then of Mbarara, just as a format for camps to make sure that nobody misses any point. Some judges have adopted their own procedures, and so there is no form that has been issued that you must use it. You look at it, there are some forms that have been developed and they are quite lacking. I find them when I go up country to do work. I find them. Some courts have adopted them, and if you look at them, they don't meet the standards of the schedule. So for me, I would like to advise, look at Schedule 2. And now remember what Justice Alan Nshimi and his colleagues have done before us. I think they say adult learning is very visual. When we see the visual, we will not forget. So if you can please have the Schedule 2 and that procedure before you, you cannot go wrong, as DCJ Emeritus has said. So let's keep to that. And any formats you find lying around, please mark them as against the standard of the rules. But don't go by them. They are not some kind of standard issue by any authority. Is there any other question? Any other observation? Yes, SG Emeritus.
Thank you very much, my Lord PJ. I was just wondering, victim involvement. We had that scenario at the university some time back, and the issue was, what is the import of the victims? And at that time, I think it was 2005, Aberdeen University in Scotland, they were introducing that, and the question was, what would happen? I don't know whether it has happened here, whether in a case where the victim or a representative of the family disagrees with the prosecution and the court. I know the court, the judge has the ultimate authority, but if they say, maybe we prefer a death sentence instead of 24 years, because our family member, that kind of question that was raised by somebody online is not coming back. What would happen? Then secondly, I wanted to find out, PJ Emeritus said this morning, he was asking for the chairman, LC1 of the area. How do you verify their statements? Because in the areas that have been, sometimes LC is also a bias. And they tend to bring issues on certain things which are not true. And this is a matter that pertains to justice, to a person, whether that person is innocent or not. And the LC comes and says, no, we have had a lot of problems of issues with this accused person, and it is not true. How do you verify those issues? Thank you.
Yes, EDJTI.
My Lord PJ, I was whispering to Justice Wangutus here when Justice Allen was doing a pre-session, and those are the similar concerns I raised. But perhaps Margaret, Susan, and Lillian will share an experience of a plea bargain I handled 3 weeks ago in Masaka. My Lord PJ, when the victims came, the accused had settled for 20 years. He killed his wife. I think they had been married for over 20 years. So I asked, I think Susan was the defense, Lillian was the prosecution, and Margaret was overseeing the process as the focal person in charge of plea bargaining in the office of the DPP. So I asked, have victims been consulted? The answer was, they are here, we talked to them. But I said, okay, where are they? They were 11, I think. Were they 11 or 9? 11. The mother of the deceased and the brothers and father to the deceased. So I gave them an opportunity to speak, and they said, he deserves death. And then I think the other one said, he deserves life. And then the other one said, 30 years. The person in charge of prosecution is in the country has settled for 20. So what I did, I called Margaret, I said, first of all, I talked to them, to the victims, sensitized them about plea bargaining. I told them how their voices are very important in the criminal justice system, and their views are not going to be disregarded, just to create comfort. And then I said, I will request that you go and have a conversation with the DPP. So they went with Margaret, and they talked. After some time, they came back with 30 years. And when they came back with 30, before I could go into plea taking, I asked the accused person whether he knew those people. He said yes. Asked him, do you know that lady? He said yes. The old lady is the mother to my deceased wife. I said, what about that old man? He said, the old man is the father. So I asked him, do you want to talk to them, tell them anything? He immediately knelt and sought for forgiveness. But in the process of the 30 years conversation, Margaret and Susan and Lillian engaged the accused person. And they came back willingly to take the 30 years. In fact, when we sentenced him to 30, they clapped. They felt like they had. Of course, the challenge I also see, what happens if the prosecution says this is the deal, and the accused person says no, and they cannot be able to sit down to agree? What happens? My Lord PJ.
Okay. I think that what you did to send the dissatisfied victim, the dissatisfied victims back to have a discussion with the state was important. Because they are the victims of the crime. They're the ones that have carried the pain, and we are supposed to take them into consideration. Who is justice for? Even if you look at Article 126. So I think at that point you'd say to them, have prosecution, you said you had had a discussion with the victims, but they are here with a different position. Did you discuss this thoroughly? Do we know why they are pushing for 30? Why are they unhappy about the 20 years? Could you have a discussion with them? And then you come back. Stage number one. Now, when they come back, if they have agreed somewhere, and maybe the state said, all right, the victim wants 30, we had initially thought of 20, but having considered the facts, we could renegotiate and maybe throw in 3, 4, 5 years more. Then they go back to the drawing board and have that discussion. But then there are times when they are being unreasonable. Let me not say unreasonable. I can imagine how bad the pain of losing someone is and why you'd want a death sentence. And you'd be right, because the law says highest penalty is death. But we usually say to them, we tell the state attorneys to manage the victims and their expectations. Manage the victims and the expectations to the extent of telling them, for example, where it's necessary, saying, well, we have the death penalty for the offense, for example, of aggravated defilement. I don't know if it has ever been handed down. So if you're insisting on the death penalty, are you being realistic or are you not? I think the swing lies eventually with the trial court and what the trial court finds to be reasonable. If at the end of the day, with these consultations, you've gone back and forth, they have settled for 25 in the plea bargain, the victims are still insisting, you will ask the state to manage the victim expectations and continue and enter your 25 years and give your good reasons as to why you've entered the 25 years. So the victims are not expected to dictate what comes out. And now it goes back to what the rules say, that it is the duty of the judicial officer to ensure justice in the whole process and that the sentence is fitting in the circumstances. If you see that there is too much emotion around it, there was a case in Soroti where somebody, I think a man, defiled and murdered a child. It was it made a lot of press. On the day he was supposed to come back for mention, the information went to the community that he was coming back to court. I don't know whether the community thought he was going to be released or something. There was a riot in the town. There are some of those cases that are so sensitive, or when you look at them yourself, you'd say, but can we go for trial? Could we go for trial on this? Again, that pedo is in the hands of the judicial officer, and you can exercise it where you see. In Masaka, there was a man who worried me. He had murdered a number of young girls. So I think there were 4 or 5 counts of murder. So the first time, the state agreed with him, I think, 25 years on every count. When they came back, I said, no, this man killed very many people. We can't do 25 years. I said, no, you renegotiate. They went back, renegotiated, and now what tickled them was that every time they suggested something, he was ready for it. I think they moved to 35, then they moved, I think, to 40, and he was just accepting everything. And I said, there must be a problem somewhere. And indeed, when we inquired, we discovered he had some mental instability. And so we went back to getting the evaluation by the psychiatrists, just to be sure that we were dealing with somebody who had the capacity to enter into a plea bargain willingly, knowingly, and understanding the consequences of it. And I must say I was a bit relieved because it was a matter that was of public interest in Masaka. And so we were saying to ourselves, this number of girls murdered by this person, how would a plea bargain of even 35 years per count, how would it be received by the members of the public? And I think these are the considerations every judicial officer makes every time when you're looking at the circumstances of the case. So the victims don't bind you, but they are the aggrieved. So how you handle them is important. And I usually throw the back to the state and I say, they are your clients first and foremost. The question of LCs and buyers. I think the challenge comes from, I think, victims of crime not being easily traceable. Sometimes the LC knows when they recorded their statement, the victim didn't have a phone number, they put the phone number of the LC1 chairperson. Or at the time that the proceedings are taking place, they cannot locate the victims by phone or any other way. But somehow the LC1 person, chairperson, is alert. But what you said is true. We need to take what they say with a pinch of salt. One, if this LC shows you, it says, oh, the victim has gone back to school, I have consulted, I have been with them. They are still in my village, though right now I cannot meet them. You have to make an assessment of what the LC is telling you and how much he may know and how much you can depend on it or what weight you can attach to it, depending on the circumstances of every case. The aspects of bias can not be eliminated. The truth is, I only recently started seeing victim impact statements. When we insisted, we started seeing victim impact statements. But in truth, I don't know the judges who are here, how many have seen a victim or community impact statement. I doubt. Usually it is the victim or somebody who knows who comes to court and then speaks out on what the impact of the crime was. In our systems, the sentencing is not as elaborate as in other jurisdictions where you have full sentencing hearing. I think you may recall Oscar Pistorius, it was almost a trial, just that aspect. But here with the plea bargain, once we have that voice of the victims, then we go with them. Where the LCs come in, it's important. And then there's another aspect that I want to mention, and that is, again, I don't know about how the ADR or the traditional ways of resolving disputes work in this area. We have heard that in the north, they have a very robust system of handling cases. Outside of court, you will find that in maybe Lango, Acholi sub-region, an accused, even Soroti, Teso, an accused person ends up in court, but in actual fact, the communities must resolve the problem. So while the accused is in prison, the families are resolving the problem. So cows have been paid, blood money has been paid, compensation has been paid. And so how do those two systems speak to each other? The ADR through plea bargain here, and then of course our traditional justice mechanisms. What many judges have done is to consider that where there has been a settlement culturally, cows have been paid, the judicial officer will take that into consideration in deciding the sentence that's appropriate. I think the Kanyamunyu case probably helps us best understand that. But it also goes for compensation, whether through the traditional mechanisms or not. If some money has been paid, compensation has been given, then you consider that again when you're coming to the sentence. Yes?
This ADR is for government. Then you go for the traditional one.
It must be said. True.
Among the language, there have been of this. But among the Cholis, if you do the traditional thing, they won't come to court because they know it has already been settled. But among the Langis, you must pay that money. And if it is a married woman who has been killed, then the husband, the husband's clan, is the one that gets the blood money. But it must be settled. Otherwise, that other one will continue from generation to generation. It will be there.
Okay. All right. Anything else?
To say that the deal is between government, state, and the accused person. The victim remains a witness for the state. So the DPP will always carry the day. until the law is changed. There is no way the victim can dictate to the DPP, who constitutionally has the final say in the matter. So that's why we want the victim to be part of the sentencing process, to know what is happening there, to be heard. But when it comes to making final decision, that is for the DPP and the accused person. For the chairman coming in, and when it was raised in Gulu, I was surprised. But the explanation were given was that those people have useful information. They may know whether the person is a thief in the village. Those people are known. And so if the chairman says this one is has a string of offenses, well, it's now up to the court to find out whether this person has any previous conviction and so on. You may find in some cases where the state is saying even the state is saying he's the first offender. This chairman may be having information to the contrary. And if it is proved, it will be to the parties. My final take on this one, you are still with RODC. If we could have what we have seen here, the sort of skit we have, if the students could be taken through that one, by the time they become their worships and their lordships, they would be experts of sorts. Yeah.
All right. It is now 4:45. It looks to me that we have exhausted plea bargain for the day. And I would like to, is there anything else? Or can we bring this to a close? Did you have something to say? All right. Please, my Lord DCJ Emeritus, we hand over to you to close us off.
My Lord, Principal Judge, my Lords, Your Worships, mediators, I think we have had a wonderful 2 days. I think let's learn from the mistakes that have already been made. We don't have to repeat them. We don't have to form new ones either. The work of a judicial officer principally is to ensure compliance with the law by everybody. Are you going to play that role when you don't follow the law yourself? The answer is no. The law we administer obliges us to follow the law as we do it. In this case, plea bargain has rules, has a procedure. At one time, I think Justice Kauka knows, some High Court judges were asking us to have a meeting between them and the Court of Appeal judges because they were revising their judgments. I told them we shall not have that meeting. We are not going to discuss how to bend the rules because we shall not do it. The answer is the law is there. You simply have to follow it. So I think that's what we are going through. These opportunities to to learn from the past mistakes is, I must say, JTI. This is wonderful. And I think I can only say thank you very much, everybody. Let's close. I was requesting for a walking team. Did we form one? Maybe I want to walk.
Thank you, my Lord DCJ, and my Lords facilitators, participants. Thank you for a good 2 days. A few announcements. One is that you were all, most of you were accommodated here, and we shared that list with you beforehand. It is important, if you didn't want to sleep here, to have notified us, because the funder has actually paid for your room for 5 days. So I needed to make that clear. Yes, there is a walk. My lords, we are going to meet at the reception. We had told them 5. Someone is going to take the lead. Someone from the hotel is going to lead us into that walk. So all those that want to join the Honorable Deputy Chief Justice Emeritus, please do so. Your drivers and bodyguards were all paid their per diems, so we don't expect that there are complaints of any sort. Thank you, my lord. I think we should meet here tomorrow at 9 a.m.